But may I have your lordship's kind leave, my lord, for upgradation of a matter that was appearing as item number 91 of your lordship, was published on last Thursday. This is an appeal. Does not relate to my lord election and everything. My lordship recalls, my lord, this is an appeal by a respondent in the writ petition, where your lordship was pleased to stay the injunction granted by the writ court restraining the respondent from using the trademarks. Well, that matter, this appeal was last heard in May, and thereafter Lordship was kind enough to list this matter on 8th June 2023.
It is not reached.
Well, thereafter, it has not reached. Well, therefore, I am praying for upgradation of this matter on any day convenient to your Lordship.
You please give the letter. Let us see.
My Lord, may I hand up the slip? I'm grateful.
May I have my lord's leave to mention a matter? I'm led by learned senior advocate Sri Bikashan Bhattacharya. Sir is supposed to join online, I think.
Doesn't matter.
Has having some difficulty, my lord. It's the MGNREG issue, my lord. The my lords has fixed the matter for 24th of August, but it hasn't reached yet, my lord. It's running as item number 72 in today's list, my lord.
Let us see. Let us progress today.
My lord, what has happened is, my lord, my lords may kindly see this one article, my lord will understand the urgency. So, my lord, the work under MGNREG Act is in suspension in rural Bengal from last 1 year, my lord. This work is their primary source of livelihood, my lord. They are hit by extreme poverty, my lord. They're committing suicide due to poverty. They're not being able to meet their basic necessities of life. And it's a constitutional promise,
So
my lord.
it's item 72 in today's.
72 in today's list, my lord. At any day of my lord's convenience, higher on board.
No, let it be the list. It should not go out of the list. We will see how we progress today. Then we'll take
If it doesn't reach today, my lord may kindly keep.
Let us see. Huh? Okay. Please call the
appellate side daily list under the heading for judgment, item number 1. I am for the appellate. I am for the
appeal stands dismissed.
my lord. I am praying stay of the judgment.
Where is the question of stay? Writ petition was dismissed, appeal dismissed.
Your lordship, I am kindly record
No.
that.
Not required.
Kindly record, my lord.
There is no executable order for which the operation is to be stayed.
Next.
Item number 2.
The time for the appellant. He study mentioned the matter that my clients are not inclined to proceed. This is my instruction, my lord. Let it be recorded. To Devin.
It's saying that he fraudulently obtained the certificate as legal means. The learned advocate appearing for the writ petitioner has written instructions from our client stating that that the petitioner does not wish to proceed further in the matter. The said letter is kept on record and the dismissal and the writ petition stands dismissed.
Grateful, my lord.
Item number 3.
Yes.
Lord, I beg to appear for the High Court administration.
Yes.
This is a matter, my lord, where the petitioner has questioned the rules framed by this honorable court relating to contempt matters, where it says that only persons aggrieved can file an application for contempt, not anybody and everybody. They say that
Somebody
why
mentioned this matter. One senior advocate, I think he's appearing from Delhi.
Oh,
He came online. They said, please list the matter someday and then give a date. Koshla. Mr. Deepak Koshla.
Oh, Mr. Kochla.
Now, there is a contempt petition, CPAN 922 of 22. It is listed before which division bench? They have recorded that CPAN is pending before another division bench. Order dated 17th January. Hmm. Hmm. But the petitioner does not have a local counsel. The
Oh.
other day itself he asked, can you ask somebody to inform the matter has been listed under the caption to be mentioned. The learned advocate appearing for the petitioner had made a mention made a mention online seeking for listing of the matter. Considering the said request, the matter was listed today under the caption to be mentioned, so that but affidavit has to be filed.
Affidavits filed.
Already filed.
No, affidavits are not being filed.
Because
And,
while
and
this-
the learned advocate general has also to be informed. You know.
yes. And yes, Union of India is also a party. No,
No. The state is a party.
state is a party. Advocate general has been
The matter was listed
to be mentioned, so that the over today, none appears for the petitioner. Let the matter appear under the same caption after some date. Let it appear under the same caption. Let us see if they have.
Next week.
Pardon?
Next week. Next week.
Item number 4,
I know that I'm appealing. With regards to item number 3,
Yes.
though I'm not a party here, but the contempt petition number 922 has been dismissed.
Dismissed.
Dismissed with 5 lakh costs.
Then you please give us a copy of that order.
I will. Yes,
Now
definitely.
you are appearing for?
Well, I am one of the contemners there.
Oh, in the contempt.
The issues are overlapping. So,
But you are not a party in
Not
this
a party.
petition.
but this is a circuitous way to go about the locus standi issue over there. Well, again, it was initially dismissed sometime on March 2023. Thereafter, the petitioner therein, who is the appearing counsel here,
He filed a recalling. The recalling got dismissed with 5 lakh rupees of cost. The matter was taken up till about 7:30 last week, 7:30 in the evening, by the division bench presided by Justice Tandon.
You are carrying that order with you,
I shall, my lord, give me 10 minutes. I'll come back with the order.
but Mr. Kaushal is not appearing today.
CPAN 922 of 2020.
সেখানে ওদের কোনো লয়ার এখানকার লোকাল লয়ার কি
Yeah.
922 of
2022.
922 of 2022. এরকম মেল করতে হবে।
No, no, maybe. What is this?
Drinking water.
Well, I have just one device. I can hand over a copy of the order. And kindly pardons me.
They have also opened it.
on the ground of locus, তাই তো?
The locus is the 13th March. There were 2 orders, my lord. One of 13th of March.
Hmm.
And this is, my lord, the order dismissed. There is a recalling filed. This is the order dismissing the recalling application.
Anjan, can we see in this screen?
13th March.
Where is the original?
13 March का पाठा। एक मिनट से पढ़िए।
এটা কি
আমার কপিগুলো পুরো মার্ক
2022.
the order by which the content petition was dismissed, that is relevant, not the recalling matter.
order 13 March. Last order position. এটা একশো টাকাই ছিল। Let me hand over a copy of the order. Yes. 13. Oh. अरे यार ওটা তো কন্টেন্ট নাম 13ই মার্চ আর একটা এই দুটোই এই দুটোই রেলেভেন্ট না ময়লাটার বলে অন্য 13ই মার্চের একটা অর্ডার আছে ওটাই মেন অর্ডারটা 13ই মার্চ
What is relevant is the first order, not the recalling. The first order is
This is the first order.
13th April. 13th April.
We got it here.
okay. Well, there is an observation regards to the pendency of this public interest litigation at page 9 of the order, second paragraph.
রিকোয়েস্ট করতে গিয়ে ঠিক আছে এরকম কিছু হয়নি এই ছেলে পুলে গেছে কিন্তু নাটক রয়েছে তো স্কুলে আমাকে ছোটবেলা অনেক ডাকতেন না স্কুলে লালু
All right, doesn't matter. Okay, let it come after 2 weeks. Give a date after 2 weeks.
We are grateful.
Sir, keep this order. Keep this order.
My lord.
That case for M3.
and
So grateful to your lordship.
and may I be permitted to say only one thing, my lord, with regard to item number 1, your lordship was pleased to dismiss the appeal in against me, my lord. What I am praying only, my lord, your lord, my junior although prayed for stay of the operation of the order, your lordship was pleased to refuse the same. Lordship kindly record that we have prayed for stay. Otherwise, my lord, it will be difficult on.
It's not an executive.
No, my lord,
order.
what-
File an appeal.
No, my lord,
We will
what happened-
upload it today. itself.
No, my lord, not on that one, but so far towards my client, we have some responsibility. That's why, my lord, your lordship can record that, your lordship, they refuse the same. They record the pray for staying of the order, thereafter your lordship kindly refused.
If there is an executable order, writ petition was
My lord, your lordship,
dismissed.
my lord, kindly record, we are
Dismissed.
also prayed for just, we have also prayed before the land single judge also staying of the order. And land single judge was pleased to, you also kindly record this and thereafter refuse the same. Only stay for, I am praying for stay. Only praying for stay and you also can refuse.
There is the question of stay. The writ petition was dismissed.
Dismissed, we prayed for stay.
Appeal has been dismissed.
That's why, my
When
lord,
do you pray for an order of stay?
my lord, your lordship, after dismissal of the writ petition, we are immediately.
What will be the effect? Let us assume you pass an order of stay.
No,
what will
we are
be the
not praying for
effect on
stay,
that?
my lord. Towards my client, we have some responsibility, my lord. That's why I'm saying.
Consider what will be the effect of that order. Let us assume that we allow your prayer for stay. Kindly consider that.
But
What will be
if
the
your
effect?
lordship stay this, that we will get the chance to prefer an SLP. In the meantime, they will not, there is a suspense and that has been also stayed, my lord.
Okay.
You also only kindly record that stay and
Not-
thereafter refuse the same.
It is your prayer, it is our discretion.
You also kindly record the same and thereafter refuse.
Your prayer, it's our discretion. Please
Man,
don't
as
mistake
your
us.
lordship, my lord.
Okay, Item 4.
Serial number 4.
Item number
Item number 3.
Ah.
2 weeks means 2 weeks takes us to 15th August. It will be, let it be on 16th because the Advocate General, I am told, will not be.
14th is not available. Don't give 14th. 14th, other matters are come. 21st. Yes,
I have submitted my affidavit of service and
and who will appear for the state?
the service were effected, my lord.
But how long water supply is not there? For several months.
Several months, my lord, and that, my lord, that scorching heat of summer has gone, my lord. The
And-
issue is very simple, but there is a crying urgency, my lord. That is why I am
Oh.
casing from last week. Last week I was bedridden, my lord. I tried from video conferencing, my lord, perhaps my lord recalled, my lord, that video
No, who-
conferencing link has gone.
Who has to put up that bore well, tube well?
At least the block development officer, at least. Since the
funds-
panchayat is not functioning,
presently.
Correct, but who has to allot the funds?
Fund will come from, so far limited knowledge is concerned, my lord. Perhaps if the state is present, they will assist,
So
my
you
lord, in a
we will
better way.
direct the district magistrate.
Yes, my lord. Perhaps the fund will come from district magistrate.
All right, by this public interest writ petition, the petitioner highlights the acute shortage of drinking water in this locality, as the only tube well which met with the demand of more than 2,000 people has not been functioning at present. In this regard, a representation has been given to all the respondents on 2/3/2023 and complaining that no action had been taken on the said representation. The petitioner has approached this court. Supply of drinking water is a necessity. And if the citizens are deprived of drinking water, then it is a very serious issue. Considering the importance of the grievance expressed, we direct the fifth respondent, namely the district magistrate, South 24 Parganas district, to immediately look into the representation dated 2/3/2023, depute one of his officers to conduct a site inspection and ensure that the tube well is repaired and water supply is restored to the in the locality. This direction be complied with within a period of 3 weeks from the date of receipt of the server copy of this order. Next.
For the statement.
What is the matter, sir?
affidavit of service. My lord, I am for the petitioner, my lord. My lord, according to the Sajal Dhara project, government we installed the project before the respondent number 8 in front of his house, my lord. My lord, in the year 2018, my lord. After that, the respondent number 8 captured the project and he stopped to supply the drinking water. He publicly announced that if you pay some price, then I shall supply the drinking water. In this respect, I made a representation before the Pradhan, police, the OC of Chandragona police station, my lord, and BDO, but no step has been taken yet. Kindly take.
Whether the eighth respondent has been served?
Yes, my lord.
But you will be appearing for the state.
Yes, my lord.
But let the BDO look into
My lord, one more submission, my lord, that the PHC department, I have been instructed to make this submission. He is the principal body who can supply the main water supply. And the distribution totally depends upon the Panchayat Pradhan. To whom he will serve, he will not serve. So for the states are concerned, my lord, we have done our part, my lord. If your lordship desire, I have.
He says that the eighth respondent has taken control.
Yes, my lord, who is that? That I don't know.
That we will not go into the allegation. Let the seventh respondent BDO examine his representation.
Lordship.
And then examine.
Yes, my lord.
The petitioner's grievance is that though a water supply scheme was put in place for supplying drinking water to the people of the locality, the eighth respondent has illegally usurped the said facility to himself. And it is alleged that the eighth respondent is demanding money from the persons in the locality for supply of water. Since the eighth respondent has not been served, we are not inclined to adjudicate the correctness of the allegations made. Nonetheless, if the drinking water supply has been put in place by utilizing the funds of the state government, water has to be supplied to all members of the locality. and no individual person can claim an exclusive right over the said water supply project. In this regard, in the light of the above, we direct the seventh respondent to consider the petitioner's representation and conduct a spot inspection of the area in question, and after notice to the eighth respondent, and take appropriate action in accordance with the law, so as to ensure that the people of the locality are not deprived of drinking water supply. That this direction be complied with within a period of 4 weeks from the date of receipt of the server copy of this order. Next.
Serial number 6.
Yes, my lord.
But I beg to appear on behalf of the petitioners, my lord.
Worship, I am appearing on behalf of the state.
But I have
For
subbed all.
respondent number 12. And for respondent number
I'm filing my affidavit.
My lord, I beg to intervene in the matter, my lord.
My lord, being aggrieved by, my lord, by the inaction on behalf of the Jila Shavadipati to maintain a public road and the encroachment by the private respondents number 11 and 12. My lord, the petitioners came before your lordships earlier by way of another writ petition. And my lord, pursuant to your lordship's direction, which is at page 29, the operating portion at page 34, the Jila Shavadipati was directed by this honorable court, my lord, to consider the representation and passed after holding a hearing to pass an order. My lord, that order has been passed. That is at page 41. My lord, I have also annexed a typed copy. As my lord, your lordship will kindly come to page 41. The order. My lord, it has been found. Kindly turn to the page. Type copy, my lord. My lord, in compliance with the honorable high, may I please, my lord, the order of
Operative portion.
operative portion is at, my lord,
Page 43.
page 43. Now in consideration, may I read, my lord?
Yes.
Now in consideration of the aforesaid and on scrutiny of the documents which have been made available in course of the hearing, and after applying my mind carefully into the facts of the case, it appears that jail number 51, plot number 471, having an area of 2.14 acres, quotas, decimal, shall be recorded as road. Have your lordships got that, my lord?
Yes.
As
We have
road.
read that.
Which after restoration shall be used for public purpose. As per the report of BLLRO, Jamuria, plot number
Now
471.
you want implementation of this order.
My lord, the learned Shavadipati has found that this land does not belong to the Jila Parishad. So he directed point number 4 at the bottom. In view of the aforesaid, SDO Asansol is hereby directed to take up the issue with AMC, Asansol Municipal Corporation, and to cause removal
of the
encroachment. I want implementation of this one.
All right. Now, who's opposing your prayer?
Lord, I oppose.
My lord, I intervene in the matter. My lord, the land that is subject matter in this petition, my lord, has been purchased by me.
No, that has been recorded. You challenge this order.
My lord, I have not been made a party in the
No,
proceeding.
no. The Jila Parishad has passed an order on 24th of, what is the date of the order?
24th February 2023.
23. You challenge that order.
Yes, my lord, I have just been informed, my lord. I beg
No,
to be
no.
implemented as a
Our
party.
client was informed much earlier. He was heard in the matter.
No, my lord, I appear for Sham Sale and Power Limited, who has not been made a party.
24th February 2023, as long as this order has not been challenged in the manner known to law, the authorities will proceed to take action. What is your objection?
But kindly takes note paragraph 9 and page 38. Lord, who is behind this litigation? Some easementary right is sought to be created through this litigation. Please have a look first at paragraph 9. At page 8
Page 8.
of the present writ application.
Yes.
The petitioner state that they made a personal representation before the director of Gagan Ferrotech Limited, being the respondent number 11, and asked him not to encroach upon the said road, but the said director of the respondent number 11 denied the same having been done by him. Not pausing here for a moment, it's an industrial area. there are several factories in the locality. The said director of the respondent number 11 also assured the petitioners that they would take steps if the neighboring company, being the respondent number 12, illegally encroaches upon the said road, and further that they would take suitable action against the said illegal encroachment. So your lordship can well visualize who is sponsoring this litigation and what is the object of this litigation.
But nevertheless, some order has already been passed.
Not, it was
You-
passed.
you-
Kindly if not keeps that open.
But after hearing both of them,
The petitioner, by this writ petitions, seeks for implementation of an order dated 24 February 2023, passed by the Sabadipati Paschim Bardhaman Zilla Parishad. The operative portion of the order reads as follows, page 43, sir. According to the petitioner, in terms of the above order, the SDO Asansol was required to take up the issue with the Asansol Municipal Corporation and cause removal of the encroachment. The you are appearing for the 12th respondent.
I appear for the respondent number 12.
The learned advocate for the 12th, appearing for the 12th respondent submitted that the writ petition is not a bona fide public interest litigation, but sponsored by the 11th respondent. There is an intervener who seeks to intervene in the proceedings, stating that the intervener is the owner of the land in question, which has been purchased by them. In any event, all the parties were heard, and the Zilla Parishad has passed an order on 24/2/2023. As long as the order has not been questioned in the manner known to law, the authorities are bound to implement the direction. With regard to the bona fides of the petitioner, the order dated 24/2/2023 was passed by the Zilla Parishad in terms of the directions issued in WPAP 274 of 2022, dated 8/8/2022. Thereafter, the parties were heard and the order has been passed. Therefore, at this juncture, we cannot examine the bona fides of the petitioner, as the earlier order passed by this court has worked itself out and culminated in an order by the Zilla Parishad. Thus, we direct the concerned SDO. SDO is a party.
yes, my lord.
Lordship, respondent number 10, your lordship.
This should
The subdivision officer Asansol to implement the order passed by the Zilla Parishad dated so and so.
no, Zilla Parishad says that I cannot do so because it is not within my jurisdiction.
Implement so and so. And the implementation of the said order will be subject to any challenge that may be made by either the 12th respondent or any third party to the said order.
Grateful.
My lord, may kindly record that, my lord, the interveners were not heard at this stage, my lord.
Next.
My lord, I am for the petition. My lord, this.
Before taking up the matter, may I tell my lord, lordship, yesterday evening, on behalf of state, I received the brief. Now, my lord, may I tell your lordship, my lord, after that, my lord, a deliberation, my lord, has been taken, my lord, with the my lord, learned GP. And today morning, it is decided that since it's a policy matter, it has been sought for. So that is why Advocate General should be here. Now, my lord, Advocate General has not yet been briefed. So let us sit with Advocate General. Let us come back on the next day, my lord, I think Monday. My lord, I think, my lord,
Fire accident took place.
My lord,
Fire accident took place. I am before your lordship with 4 limbs of prayers. First, lordship, this entire land, which consisting of around 1400 square meters of area. Now, lordship, a board is there, which can be shown, and it can be ascertained from the state that this land is presently, it is reported in the newspaper, is owned by some private entities. Now, under the provisions of the Urban Land Sealing Regulations Act.
No, already the government is looking into it.
Yes.
Even
Malad,
today,
yesterday,
the
Malad,
government
Chief
is a
Minister has
report.
made a statement
Let
in
the
the
government
assembly.
Let them get instruction.
Yes.
Let the
We have heard the learned so and so, the learned government council submits that the papers in the writ petition was served in the office of the government pleader late yesterday evening, and he does not have instruction and seeks for adjournment. List the matter next Tuesday,
Get.
not next Tuesday, once again.
Lordship, may I seek for one thing? Lordship?
Malad, after 14 Lordship, because
Yes, list on 22nd August.
my get.
Next,
Lordship, may I only seek for one thing? Since they are taking the instruction, let them take the instruction on a particular point regarding the vesting of
On
the
all
land
points.
in
we
favor
shall
of the
take
government.
instruction.
you have enclosed a couple of photographs from the newspaper and you have filed it.
Vesting of the
And
land
the
is important.
traders have not come here.
No, Lordship, vesting, we are for the government. We want the land to be vested in favor of the government.
So this proxy.
Land in heart of the city.
This proxy litigation we can't.
This,
If the traders have come to saying that, sir,
Lordship, it's a question, it's Asia's biggest, largest heart.
maybe, see the condition of the hut. Obviously,
It has to be developed, the infrastructure. has to be
no, I don't think so. Let the traders come. Why are you, somebody is riding some horse, somebody is
It's a question
firing
of
off
the
somebody's
city.
shoulders.
Heart of the city, these things are.
No, I don't think so.
I will try to satisfy your lordship on this, lordship. Whether the citizen has a right.
Get.
Serial number 8, 22nd August.
Lordship, I beg to appear on behalf of the petitioner. In this matter, my lord, the petitioner has paid for registering an FIR against the 21st July. Some speech has been made on the
Sir, you file a complaint, sir. You file a complaint. We have held such prayer is not made. The learned advocate for the petition seeks permission to withdraw this writ petition and seek remedy before the appropriate forum. Dismiss, writ petition dismissed with the aforesaid liberty. Next.
Serial number 9.
Yesterday, our lordship observed.
You do something. You do it in a proper manner.
But this matter, my lordship was kind enough to hear it on the last occasion.
Well, I am for the applicant. Mr. Mitro is also leading.
Oh, since Mr. Mitro is there, okay.
May it please your lordship. Oh, Mr. Bhattacharya is here. Nice to see him from a distance.
I'm relieved. I'm relieved. Mr. Mitro's presence.
My lord, in this matter, my lord, your lordship will be pleased to recall, the matter is pending before the adjudicating authority under the Prevention of Money Laundering Act. My lord, we took the point that whether the adjudicating authority had the jurisdiction sitting singly to hear the matter. And we relied upon the provisions of the Prevention of Money Laundering Act to submit to the learned trial judge that in fact, the jurisdiction of the adjudicating authority is of the adjudicating authority as defined, my lord, under this particular act. And under this act, well, if your lordship kindly takes the provision, section 6.
On the last date, we made certain observation and the learned advocate sought time to get instruction in the matter.
Well, please, our contention is this, that the adjudicating authority who is now hearing the matter is quorum non judice, because, my lord, it has not been constituted in terms of section 6. Kindly see, my lord, section 6 of the act. It says the adjudicating authorities, composition, powers, etc. The central government shall, sorry, your lordship has got a copy of that. Section 6, my lord.
Yes.
The central government shall by notification appoint an adjudicating authority to exercise jurisdiction, powers and authority conferred by or under this act. Then 2, an adjudicating authority shall consist of a chairperson and 2 other members, subsection 2. Provided that 1 member each shall be a person having experience in the field of law, administration, finance or accountancy. Remember, I pause here for a moment. My respectful submission is this, that these tribunals were constituted
to, my lord, to lighten the burden of the regular courts. And, my lord, it was expected that these adjudicating authorities should be consisting of persons having different experience, varied experience in different fields. And that is why, my lord, it has been said that adjudicating authority shall consist of a chairperson and 2 other members, and the members will be from the field of law, administration, finance, or accountancy. Then a person shall, however, not be qualified for appointment as member of an adjudicating authority in the field of law unless he is qualified for appointment as district judge, 2, has been a member of the Indian Legal Service and has held a post in grade 1 of that service, and B, in the field of finance, accountancy, or administration unless he possesses such qualification as may be prescribed. My respectful submission is the provisions of law is absolutely clear as to what an adjudicating authority should consist of. It has to be consisting of a person in the field of law, administration, finance, and accountancy. And, my lord, in 3A, in the field of law, he is qualified for appointment as a district judge, no less a person, and has been a member of the Indian Legal Service and has held a post in grade 1 of that service. Well, at the moment, the adjudicating authority consists of 1 person, and he is not from the field of law. He is, a field from the accountancy. Administration, if gentleman from administration is coming from the finance department, and the judicial temperament which is required for the purpose of proper adjudication of this kind of disputes, my lord, in my respectful submission, is completely lacking. Then, subject to the provisions of this act, the jurisdiction of the adjudicating authority may be exercised by benches thereof. B, a bench may be constituted by the chairperson of the adjudicating authority with 1 or 2 members as the chairperson of the adjudicating authority may deem fit. Well, I am reading this particular provision like this. A bench may be constituted by the chairperson of the adjudicating authority with 1 or 2 members. That means chairperson should be there, and with 1 or 2 members as the chairperson thinks fit. Has to be, my lord, more than 1 person. That is my reading of this particular provision. Then C, the benches of the adjudicating authority shall ordinarily sit at New Delhi, and such are the places the central government may, in consultation with the chairperson, by notification specify. Then D, the central government shall, by notification, specify the areas in relation to which each bench of the adjudicating authority may exercise jurisdiction. Then 6, notwithstanding anything contained in subsection 5, the chairperson may transfer a member from 1 bench to another bench. Well, these are all indicating the fact that there has to be more than 1. Here also, the indication is, notwithstanding anything contained in subsection 5, the chairperson may transfer a member from 1 bench to the other. Well, I cannot conceive of 1 person sitting over there, and, my lord, he is dealing with the matter. I don't know how he is going to transfer himself from 1 bench to the other. Then 7, if at any time, any stage of this is the provision on which reliance is being placed by the other side. If at any stage of the hearing of any case or matter, it appears to the chairperson or member that the case or matter is of such nature that it ought to be heard by a bench consisting of 2 members, the case or matter may be transferred by the chairperson, or as the case may be, referred to him for transfer to such bench as the chairperson may deem fit. Well, here I am construing this particular provision to submit to your lordship that the chairperson has to constitute a bench consisting of more than 1 person, either with himself and somebody else, or with 2 other persons, keeping himself away. But, my lord, the bench has to be consisting of more than 1 person. Then 8 is, the chairperson and every member shall hold office as such for a term of 5 years from the date on which he enters upon his office, provided that the chairperson. My lord, the serious question has arisen as to whether what was intended by the legislature in constituting an adjudicating authority is being complied with at the moment. With 1 person, my lord, sitting over there, coming from finance department, having, I should not say that having no experience in judicial matters, but
what was contemplated, I refer your lordship to L. Chandrakumar's judgment. The courts have said that at this kind of tribunals should be consisting of at least one judicial member, so that, my lord, if I may use the expression, sanity may prevail. In the sense that government officer coming and, my lord, sitting over there, that is a natural inclination to, my lord, to act in favor of the government. The interest of the government will, of course, interest of the government should be looked after. But there has to be some kind of a temperance in the entire atmosphere of this body, adjudicating authority, so that, my lord, the judicial temperament may prevail. This is totally absent here. Therefore, my lord, I am respectfully submitting to your lordship, reading these provisions together, perhaps one can contend before your lordship, and this is a matter of interpretation, that it is necessary for a body like this to have a judicial member, without which, my lord, the body cannot work. And in fact, my lord, our grievance is this. My lord, I would only request your lordship to look into on this particular aspect of the matter. There had been various judgments. My lord, I do not want to trouble your lordship. Well, this kindly look at this judgment in Parina Sarup versus Union of India. Only one or two paragraphs in which, my lord, the Supreme Court's views on the subject is very clear. Oh, sorry, copy. I got copy. Well, kindly take, my lord, paragraph 9. This is, my lord, with regard to Prevention of Money Laundering Act, BMLA Act, my lord. Kindly come to first, my lord, Mrs. Satyasivam judgment. The first paragraph is, Ms. Prerna Sarup, member of the bar, has filed this writ petition under Article 32 of the Constitution of India by way of public interest litigation, seeking to declare various sections of the Prevention of Money Laundering Act, such as Section 6, which deals with adjudicating authorities, composition powers, etc., Section 25, etc., etc. Members of the appellate will resign, so and so, provisions in breach of the scheme of constitutional provisions and power of judiciary. Then, my lord, I am not troubling your lordship with these details of these facts. Kindly come to paragraph 4. It is highlighted that the provisions of the Act are so provided that there may not be independent judiciary to decide the cases under the Act, but the members and the chairperson are to be selected by the selection committee headed by the Revenue Secretary. It is further pointed out that the constitutional guarantee of a free and independent judiciary and the constitutional scheme of separation of powers can be easily and seriously undermined if the legislatures were to divest the regular courts of their jurisdiction in all matters and entrust the same to the newly created tribunals. Then, my lord, kindly come to para 9. It is necessary that the court may draw a line which the executive may not cross in their misguided desire to take over bit by bit the judicial functions and powers of the state exercised by the newly constituted courts. While creating new avenues of judicial forum, it is the duty of the government to see that they are not in breach of basic constitutional scheme of separation of powers and independence of the judicial function. We agree with the apprehension of the petitioner that the provisions of Prevention of Money Laundering Act are so provided that there may not be independent judiciary to decide the case under the Act, but the members and the chairperson to be selected by the selection committee headed by the Revenue Secretary. It is to be noted that this court in L. Chandrakumar has laid down that the power of judicial review over legislative action vested in the High Courts under Article 226, as well as this court under Article 32 of the Constitution, is an integral and essential feature of the Constitution, constituting part of its basic structure. The Constitution guarantees free and independent judiciary, and the constitutional scheme of separation of powers can be easily and seriously undermined if the legislature were to divest the regular courts of their jurisdiction in all matters and entrust the same to the newly created tribunals, which are not entitled to protection similar to the constitutional protection afforded to the regular courts. The independence and impartiality which are to be secured not only for the court but also for the tribunal and their members, though they not only for the though they do not belong to the judicial service but are entrusted with judicial powers. The safeguards which ensure the independence and impartiality are not for promoting personal prestige of the functionary, but for preserving and promoting protecting the rights of the citizen and other persons who are subject to the jurisdiction of the tribunal, and for ensuring that such tribunal will be able to command the confidence of the public. Freedom from control and potential domination of the executive are necessary preconditions for the independence and impartiality of the judges. To make it clear that a judiciary free from control by the executive and the legislature is essential if there is right to have the claims decided by the judges who are free from potential domination by other branches of the government. With this background, let us consider the defects pointed out by the petitioner and amended proposed provisions of the Act and the rules. Then, my lord, the court has gone into the details of it in the form of, it has been, my lord, set out in the form of columns. And then, my lord, kindly come to the last page at page 114, or I should say 113 at the bottom. Page 113, bottom. Last paragraph 2. PMLA is a specialized and new act, and district judges may not be available. I'm sorry. Your lordship has got that?
Yes.
At the bottom of the last paragraph. PMLA is a specialized and new act, and district judges may not be available with experience in related issues, whereas advocates or other officers of Indian legal service who are eligible to be district judges may often have greater knowledge of its provisions and working. This is, my lord, quite a, I should say, very encouraging statement by the Supreme Court. Then, my lord, kindly come to the last paragraph, paragraph 5. Very well, paragraph 3. The adjudicating authority is a body of experts from different fields to adjudicate on the issues of confirmation of provisional attachment of property involved in money laundering. The functions of the adjudicating authority are civil in nature to the extent that it does not decide on the criminality of the offense, nor does it have the power to levy penalties or impose punishment. Adjudication is a function which is performed by executive under many statutes. The competent authority under so-and-so have been conducting adjudication proceedings routinely since 1978. And in the last 4 years, that is 2004 to 2008, competent authority has taken 1,374 new cases, etc. Then the last paragraph, paragraph 5. The adjudicating authority, being a body of experts from different fields with a role as described in para 3 above, appointment of its chairperson should be left to the recommendation of the selection committee. Well, I am respectfully submitting to your lordship, it has to be a body of experts. And my lord, that is what is being contemplated in section 6. And if that is so, then my lord, a body, it cannot be constituted of one person only. What is being contemplated is there should be a body consisting of persons from different fields, including the field of law. And my lord, it is not that being a lawyer, I am insisting on a lawyer being present or a person experienced in law being present in the committee. But what I am submitting to your lordship is this, that there is a basic wisdom in these provisions. These provisions were, my lord, formulated previously, my lord, the tribunals were not there. When the tribunals were constituted, the court thought, the legislature thought that the court's power should be exercised by a body which will be as good as the court. And my lord, for the purpose of, my lord, manning it, there should be at least one person with, my lord, judicial temperament. District judge, that is what was prescribed. And my lord, I submit to your lordship that this provision, as I have read it, my lord, maybe I am not reading it correctly, it does not, my lord, conceive of a situation where there should be only one person, and that too not from law. So, my lord, we are challenging the jurisdiction of this particular body, I say that you cannot decide the issues without being properly constituted. If you are not properly constituted, then you are quorum non juris. And therefore, my lord, any decision that you take will not be binding on the party concerned. This is an important point because this issue is arising over and over and over again. And my lord, it has gone to the Supreme Court, and Supreme Court in various decisions, including the decision which I just now cited. My lord, I find that in 2021, 7 Supreme Court cases, another decision has been made by a bench consisting of 3 learned judges of the Supreme Court. If your lordship want, I can just place one paragraph in that. This is, my lord, Madras Bar Association versus Union of India. And this was, my lord, considering the constitution of courts, tribunals, and judiciary. I just take your lordship, this is a lengthy judgment. I take your lordship straight to para 50. Copy para 50. We would wish to emphasize here that the setting up of tribunals and the subject matters they are expected to deal with, having regard to the challenges faced by a growing modern economy, are matters of executive policy. When it comes to personnel who would operate these tribunals, given that the issues they decide would ultimately reach the court in appellate review or in some cases judicial review, competence, especially in matters of law, as well as procedure to be adopted by such judicial bodies, becomes matters of concern for this court. These tribunals discharge a judicial role, and with respect to matters entrusted to them, the jurisdiction of civil courts is usually barred. Therefore, wherever a legal expertise in the particular domain is implicated, it would be natural that advocates with experience in the same or ancillary field would provide the catchment quote unquote, for consideration for membership. This is also the case with selection of technical members who would have expertise in the scientific and technical or whenever required policy background. These tribunals are expected to be independent, vibrant, and efficient in their functioning. Appointment of competent lawyers and technical members is in furtherance of such judicial independence. My lord, I could not have been more vocal than this. My lord. This is most eloquent way it has been put. My lord, I respectfully will submit to your lordship, in the facts of this incident case, perhaps it is a matter of concern for the court also, because after all, the matters will ultimately come to the court, that the adjudication at that level will have to be, my lord, a competent adjudication, not a, my lord, partial and, my lord, biased adjudication. My lord, therefore, my lord, I am submitting to your lordship, I am taking this short point. I said that there should not be only one member. Has to be, my lord, more than one. Well, these are my respectful submissions. Your lordship can give me. Mr. Bhattaji is not there. If there is anything else, my lord, I have left out, perhaps he can, he could have supplemented.
Yes.
Well, these are my responses.
My lord, since the issue is very short, I will confine myself to that only. My lord will kindly take section 6 for once. Again, my lord has seen the entire provision. My lord, senior opposition has read the entire section 6 up to subsection 8. Kindly take this for another moment. My lord, the section 6, subsection 2 states that an adjudicating authority shall consist of a chairperson and 2 other members. But it does not say that the bench will be of that strength. It says that adjudicating authority shall consist of 1 chairperson and 2 other members. Then, my lord, will directly come to subsection 5. Subject to the provisions of this act, A is important. The jurisdiction of the adjudicating authority may be exercised by benches thereof. Now, what is the bench? Kindly come to B. A bench may be constituted by the chairperson of the adjudicating authority with one or two members as the chairperson of the adjudicating authority may deem fit. Now, my lord, my learned senior friend, if I have understood correctly, have tried to demonstrate the chairperson will remain there with him one or with him two members. This is his reading of this particular provision. So, my lord, according to him, the bench should be either of two judges, two members, or of three members. Now, my lord, I read it, a bench may be constituted by the chairperson. So, the duty of the chairperson is to constitute a bench with one or two members. So, the bench will be single or division. Now, my lord, kindly come. This reading is corroborated by subsection 7.
Yes.
If at any stage of the hearing of any case, so my lord, the hearing is going on, or matter, it appears to the chairperson or a member that the case or matter is of such a nature that it ought to be heard by a bench consisting of two members. That means, my lord, the rule is single member. In course of hearing before a single member, if the chairperson or a member who is hearing the matter is of the opinion that the matter is of such nature that it ought to be heard by a division bench, then the case or matter may be transferred by the chairperson, or as the case may be, referred to him for transfer to such bench as the chairperson may deem fit. My lord, subsection 7 makes it clear that the rule is hearing before a single judge. Only in case where there is of such a nature. If chairperson himself thinks, he can transfer. Or if a member thinks so, he will refer to the chairperson. The last part of subsection 7. Or as the case may be, referred to him for transfer. So if a member hearing a matter singly decides that it is of such nature, it should be heard by two members, he will refer it to the chairperson. That kindly transfer it to the division bench. Then only it will be done. My lord, I do not find there is any ambiguity in this provision. Now, so far as the second part is concerned, that whether a judicial member is necessary to apply the judicial mind, or in absence of a judicial member, there will be no judicial mind and there will be no application of law. My lord will kindly take sections 3, subsection 3, a person shall, however, not be qualified for appointment as member of an adjudicating authority. My lord, A relates to judicial member. Then kindly come to B. In the field of finance, accountancy, or administration, unless he possesses such qualification as the case may be. My lord, both are not required. Either I will fall under A to be a member, or I will fall under B. So, to be a member, if I possess a qualification in the field of finance, accountancy, or administration, having such qualification as is prescribed, I'm entitled. Now, my lord will kindly see section 28 for once. Now, it has been omitted. Now, yes. Earlier, it was saying that how the member and qualification for appointment will be such and such. Now, here, my lord, I would refer that this particular matter, my learned senior friend showed some judgment on issues. This particular matter was before the Honorable Delhi High Court, that whether a single member can hear under section 6 or not. It has been decided by the Honorable Single High Court, Delhi High Court, in the case of, firstly, in the case of Shekhar J. Reddy. Now that matter went to the Supreme Court at the instance of ED on some different issue. The issue was, another issue was decided that in every stage of proceeding, reasons to believe, recorded reasons to believe, to be supplied. Now, whether it has to be supplied or not, on that portion, SLP is pending. So far, the other part is concerned, the other part has been confirmed. Other part has been confirmed, And subsequently, the other part has been considered by the Honorable Delhi High Court, in this case of Olokananda Realtors Private Limited and others. My lord will kindly first take paragraph 3 at page 4.
Paragraph 3, page 4.
Page 4, sir.
Yes.
On the other issues which was addressed before the court related to the competence and jurisdiction of the adjudicating authority proceeding further, bearing in mind the fact that it presently comprises of a single member. It was the submission of the learned senior counsel who contended that a single member cannot possibly be recognized to be an adjudicating authority duly constituted in terms of section 6 of PMLA. The court is also informed that a similar challenge is pending consideration before the High Court for the state of Telangana in Messrs. Indus River Health Sciences Limited. However, and as was rightly pointed out by Mr. Hussain, the issue of whether a single member can act as an adjudicating authority has been duly considered and answered by a division bench of the court in J. Shekhar versus Union of India 2018 such and such, where the following observation came to be made. Composition of A and AT. The court next takes up the question of the composition of A, on which extensive arguments were advanced by the learned counsel for the petitioners. In this context, it must be noticed that under section 6 PMLA, the A is supposed to consist of the chairperson and 2 other members, one of whom shall be person having experience in the field of law. Section 6.3 further sets out that the qualification for appointment as a member of an A should be: one of those qualifications is that the person has to be qualified for appointment as a district judge or a person in the field of law or a member of an Indian legal service. The other qualification is possession of a qualification in the field of finance, accountancy, or administration, as may be prescribed. It is therefore not the case that all the members of the A should be a judicial member. It is seen that section 5 of the jurisdiction of A may be exercised by the benches thereof. Under section 6(5)(b) PMLA, a bench may be constituted by the chairperson of A with 1 or 2 members as the chairpersons may deem fit. Therefore, it is possible to have single member benches. The word bench, therefore, does not connote plurality. There could, even under section 6(5)(b) PMLA, be a single member bench. When section 6(6) of PMLA states that a chairperson can transfer a member from one bench to another bench, it has to be understood in the above context of there being also single member benches. The court is unable to agree with the submission that since the adjudicating authority procedure regulation 2013 requires every order sheet to have a signature of the chairperson and the members constituting the bench, it necessarily means that every matter has to be heard by a bench comprising the chairperson and members. This would be an erroneous interpretation which is contrary to the main provision of PMLA itself by section 6(5)(b) of PMLA. Likewise, under Rule 3 of Prevention of Money Laundering, appointment and condition of service of chairperson and members of the adjudicating authority rules 2007, although it states that A should have 3 members, that has to be read along with section 6(5)(b) that there can be single member benches. A contrary interpretation would actually frustrate the working of the A. The court therefore rejects the contention of the petitioner that there cannot be any single member benches of the A. It was contended, then L. Chandrakumar, I am not reading that, the reliance of L. Chandrakumar, my lords can skip that. Thereafter, ATAP, the tribunal constitution is there. My lord can directly come to paragraph 5 at page 7. Although the court is aware that the aforesaid decision has been placed in abeyance in an appeal preferred by the directorate, albeit preferred with respect to certain unrelated aspects of that decision, it also bears in mind the salutary principle that while a stay of the judgment may defer its enforcement inter partes, it does not efface the dictum thereof. In any case, it would be proper for this court to either consider or tread down a path different from what was laid down in J. Shekhar, merely on the ground that a stay has been granted on the appeal by the directorate. The principal apprehension of the petitioner, which was then expressed, was that if the adjudicating authority were permitted to continue further, it may also result in them facing the spectra of being deprived of possession of property in question if ultimately power is confirmed. Well, here in this case, question of power, provisional attachment order is not in question. Here the fact, my lord, I should indicate in 1 second, my lord, some mobile phone and laptop has been seized. Now, in terms of section 17, subsection 4, the enforcement directorate is duty bound to make an application before the adjudicating authority to retain such seized goods. And the adjudicating authority is having a total period of 365 days to complete from that. Now that period has already over. I would be praying for extension of time if I succeed in this. Now, my lord, after this judgment event, there is another judgment passed by Honorable Delhi High Court.
The appeal is by the enforcement directorate.
Yes, on the issue that whether at every stage, because if, my lord, I place J.
No, obviously, this finding is in favor of the enforcement directorate.
Against that, no
You
appeal.
can't file an appeal.
Against that, no appeal. Now, my lord, there is another case. It is in the case of Messrs. Goldcraft Properties Private Limited. It is further clarificatory. But paragraph 3 first, in the first page. The present petition challenges the impugned order dated 25th January 2023, passed by the appellate authority under the Prevention of Money Laundering Act. By the impugned order, the appellate authority has rejected an application filed by the petitioner seeking transfer of the proceedings to a bench in terms of section 6(7) of PMLA. My lord, I showed your lordship 6(7). There is a transfer from single to division bench. Now, there was a petition in this case, which was rejected. Now, my lord, kindly take paragraph 12 at page 5. In the present case, the petitioner seeks the constitution of a bench under section 6(7), consisting of 2 members at the adjudicating authority level for the purpose of deciding the confirmation of the impugned provisional attachment order. Section 6(7) of PMLA reads as under. Now kindly come to paragraph 30. A perusal of the said provision would show that it is only at the time of hearing in any matter, if the chairperson or a member feels that the matter or case is such a nature that it ought to be heard by a bench of 2 members, then the chairperson may assign a 2-member bench for hearing of the said order. In the present case, there has been no opinion expressed by the adjudicating authority to the effect that the matter is so complex so as to require a 2-member bench. The petitioner in this case has moved an application seeking constitution of 2-member bench, the maintainability of which itself could be suspect in as much as there has been no opinion expressed by any member of this should be A, that such a bench is required. In fact, in the opinion of this court, the proceeding under PMLA Act is general of such a nature that they involve analysis of both accounts and finance. It therefore cannot be said that a bench consisting of 1 member cannot adjudicate the dispute until and unless a special case is made out for transfer to a bench of 2 members. A bare perusal of the relevant provision, section 6(7) of PMLA would itself reveal that it does not contemplate an application being moved by a party to seek constitution of a 2-member bench. If such applications are permitted, it may lead to a situation that in every case, the concerned parties or entities would move an application for constitution of such a bench merely to delay proceedings. Sorry. Time is the essence under the provisions of PMLA Act, and decisions in respect of provisional attachments have to be taken within a prescribed time, which is usually 180 days. Under such circumstance, the moving of an application, as has been done in the present case, would be nothing but a delaying tactic, purely with an intent to delay the matter. The adjudicating authority has rejected the application filed by the petitioner, and the matter is now stated to be for final hearing before the adjudicating authority. In such a situation, this court is of the view that an application under section 6 and 7 would not even be maintainable. Now, my lord, my humble submission before your lordship is this, that if your lordship looks into the impugned order, if your lordship, because they are against an order passed by the honorable single judge in this present case, my lord will kindly take that order for once. हाँ ठीक है, चलो.
Page 8, para 25 onwards.
My lord. Para 30 is the ultimate finding, my lord. Huh? Regarding the impugned order, the single judge. Yes.
29 and 30.
Yes, well, they have that is on the point of constitution of quorum non judice. Now they have abandoned the other issues which were raised before the honorable single. They have not pleaded before this honorable division. Why I have referred to this order particularly, because while passing this order, the honorable single judge was considering the entire fact and gamut of this matter. My lord will kindly see. Paragraph 46 at page 12.
Yes. Yes.
The repeated attempts of the petitioners to come up in challenge in connection with the pending proceeding indicates that the petitioners want to stall the same unnecessarily. Such dilatory tactics on the part of the petitioners ought not to be encouraged. It would be relevant in the context of the allegation of undue haste of the adjudicating authority leveled by the petitioners to examine the statement of objects and reasons of the PMLA, which stresses that it is being realized world over that money laundering possesses a serious threat not only to the financial system of the countries, but also to their integrity and sovereignty. In view of an urgent need for the enactment of a comprehensive legislation inter alia for preventing money laundering and connected activities, within which serious crimes like illicit drug trafficking have also been included, confiscation of proceeds of crime, setting up of agencies and mechanisms for coordinating measures for combating money laundering, etc., the connected bill was introduced. The seriousness and implicit urgency involved in a proceeding to combat such grave issues would justify some amount of urgency. Thus, it cannot be said that merely because the adjudicating authority is trying to expedite the proceeding, it is biased against the petition. But why I refer to this? A seizure search and seizure made, a laptop, 2 mobile phones seized. Now, the accused was called upon to come and join and participate in the forensic opening of those electronic devices. They moved the petition before the special court, saying that some forensic experts must be presented, must be appointed. special court rejected. They came up in a revision. The enforcement, on behalf of enforcement directorate, I had the opportunity to appear before the honorable court. Before the matter could be opened, I said that there is no requirement to go into these details. Let this be sent to any CFSL. Let the argument be stopped. And the honorable single judge referred the matter to CFSL with a direction that you open and thereafter you extract data and you give within such and such time period. Complied. Then an application for 17.4 when made to retain these properties. They came up with another revision first by saying that when this honorable court said that it has to go to CFSL, they cannot go to AA. Well, those have no connection. The revision has been dismissed on that very day. After being dismissed, they filed this writ petition, saying that quorum non juris, saying that bias, saying that no hearing opportunity. The entire procedure of 17.4 only, at the stage of 17.4, could not be completed by this repeated action of this petition. Well, the act of the petitioner, the main person behind this RP Infosystem Limited is the main director who is now behind the bar in respect to another case of PMLA. A repeated offender coming before this honorable court, either in divisional jurisdiction or in the 226 jurisdiction on repeated occasions, only in order to stall the proceeding, as has been observed by the Honorable Delhi High Court also in the case of Goldcraft. If it is allowed, it is only to allow them to stall the proceeding. Now, my lord, the constitution of single member bench in an AA is beyond dispute according to my humble understanding. So far as the judgments referred by my learned senior friend opposite, but kindly take the first judgment, Parina Saru. My lord, actually I am grateful to my learned senior friend. It supports my case. My lord, kindly come to directly to the last page, that is page number 114. My learned senior friend first referred to paragraph 3, paragraph 4, and paragraph 9 and 10. My lord will find paragraph 10 is all about constitution of appellate tribunal. But the appellate tribunal in the PMLA is different than adjudicating authority. Appellate tribunal, constitution of appellate tribunal, functioning of appellate tribunal, all are under separate provision. It starts at chapter 6, section 25, 26, and there are 35 because the other provisions have been omitted. So it is under chapter 6. So paragraph 10 of this judgment only talks about the tribunal, which is under chapter 6. It is not about adjudicating authority. So far as adjudicating authority is concerned, it starts from paragraph page 113, bottom, serial number 2 only. Page 113, bottom, serial number 2. Kindly come to the next page, serial number 3. 3 and 4 supports my case.
Yes.
The adjudicating authority is a body of experts from different fields to adjudicate on the issue of confirmation of provisional attachment of property involved in money laundering. Well, the next sentence, kindly, my lord, mark, the functions of the adjudicating authority are civil in nature to the extent that it does not decide on the criminality of the offense, nor does it have power to levy penalty or impose punishment. Then, my lord, adjudication is a function which is performed by executives under many statutes. The competent authority under NDPS, SAFEMA, have been conducting adjudication proceedings routinely since 1978. And in the last 4 years, that is 2004 to 2008, competent authority has taken 1,374 new cases, issued 275 show cause notices, forfeited 162 properties, and disposed of 30 properties without any judicial objection. Similar adjudication are done by the custom authorities under Custom Act or by authorities under FEMA or FIRA. The adjudicating authority, being a body of experts from different fields with a role as described in para 3 above, appointment of its chairman should be left to the recommendation of the selection committee. Then after the chart, my lord, paragraph 12, inasmuch as the amended stroke proposed provisions as mentioned in para 11 are in the tune with the scheme of the constitution as well as the principles laid down by this court, we approve the same and direct the respondent Union of India to implement the above provision. Well, this inter alia includes that non-appointment or non-presence of a judicial member as an adjudicating authority does not vitiate the adjudication power. It does not require. It is not the tribunal. Perhaps my learned friend senior has derailed himself by confusing between the tribunal and the adjudicating authority. We are concerned about adjudicating authority only. Now, the second judgment of Madras Bar Association, my lord will kindly take. My learned senior friend has referred to paragraph 50 at page 400. My lord, with deepest respect, every sentence of this paragraph talks about setting up of tribunal. Kindly see. We would wish to emphasize here that the setting up of tribunal, the next sentence, when it comes to personnel who would operate these tribunals, then the third sentence, these tribunals discharge a judicial role. Well, each and every sentence of this paragraph talks about the constitution functioning of the tribunal. The next sentence is also same. These tribunals are expected to be independent. I'm not saying that adjudicating authority will not be independent, but this paragraph at least does not refer to adjudicating authority. If this paragraph is to be equated with the adjudicating authority, my lord, then under every act, every single act, the adjudicating authority has to be reconstituted by the order of this honorable court, my lord. Deeply obliged, my lord. I am praying for upholding of the order passed by the honorable single judge, my lord. Deeply obliged.
My lord, may I just deal with these decisions which have been cited? My lord, what, my lord, has not been addressed to your lordship is, my lord, what I submitted with regard to the constitution of the adjudicating authority. My submission, these judgments, first of all, kindly take, my lord, the Delhi judgment, the Olokan on the realtors. What is the dispute between the parties? What was the matter before the court? Lordship, will you please to see paragraph 3. One of the other issues which was addressed before the court related to the competence and jurisdiction of the adjudicating authority, proceeding further, bearing in mind the fact that it presently comprises of a single member. It was a submission of the learned senior counsel who contended that a single member cannot possibly be recognized to be an adjudicating authority duly constituted under Section 6. The court is also informed that a similar challenge is pending before the High Court for the state of Telangana. However, as was rightly pointed out, Mr. Hussain, the issue is whether a single member can act as an adjudicating authority has been duly considered. Well, pause here for a moment. What is being said here is this, that one member can constitute an adjudicating authority, provided the bench is there. What is being said here is interpreting Section 6. The chairman of the adjudicating authority can constitute a bench. I am not disputing that. But it has to be a bench of 3, and then at least 2 persons should be present, and 1 person can be assigned. This is what is being said here. my lord, my respectful submission is this. This judgment does not militate against my submission that if the adjudicating authority has to be considered. My lord, it is, kindly see the language. An adjudicating authority shall consist of a chairperson and 2 other members. Now, my lord, if after the adjudicating authority has been constituted, the chairperson assigns a particular matter to a single person, understandable. I will not question that. But what I'm saying is this: what is this body? Is it the adjudicating authority as contemplated under section 6? Your lordship will be pleased to see that quotation has been given in this judgment, Alokananda's judgment, of the division bench of J. Shekhar versus Union of India. The lordship will be pleased to take my lord, the paragraph 79 has been quoted. The court next takes up the question of composition of AA, on which extensive arguments were advanced by the learned counsel for the petitioner. In this context, it must be noticed that under section 6 of PMLA, the AA is supposed to consist of the chairperson and 2 other members, one of whom shall be a person having experience in the field of law. Section 6(3) further sets out the qualification for appointment of a member as member of the of an AA should be. One of those qualifications that is a person is a then para 80. It is seen then under section 5A PMLA, the jurisdiction of the adjudicating authority may be exercised by the benches thereof. Under section 6(5) of PMLA, a bench may be constituted by the chairperson of the AA. There has to be a chairperson, and he has to constitute a bench. Then only that particular bench will be, my lord, clothed with the jurisdiction to decide the question. By himself, one person will not be entitled to decide. The chairperson has to constitute the bench, either with 2 or with 1, depending upon the nature of the dispute. And that particular, once that constitution is made, that cannot be questioned. But adjudicating authority has to have these 3 members. Therefore, this particular judgment, from that point of view, well, kindly see, that is what exactly section 80, paragraph 80 says in this judgment. Therefore, it is possible to have a single member bench. The word bench, therefore, does not connote plurality. There could, even under section 5B of PMLA, be a single member bench. When section 6(6) PMLA states that a chairperson can transfer a member from one bench to another bench, it has to be understood in the above context that there also being a single member benches. Well, your lordship, the Chief Justice of this court, can constitute bench. My submission is this: your lordship can constitute single member bench, division bench, but it is your lordship who has to constitute it. Then only, my lord, that particular bench will have the jurisdiction to, my lord, undertake the exercise, judicial exercise. My submission is this, that this judgment does not impinge on the issue that I am adverting to your lordship. It's a purely, my learned friend has said a lot of prejudicial things. I am not going to defend my client on any aspect of the prejudicial matters. I am on a pure and simple aspect of law. Whether this is justified, this is my submission, or not justified. This judgment does not really impinge on the issue that I am raising. I am submitting to your lordship, have an adjudicating body. That adjudicating body will be consisting of a chairman and 2 other members, or 1 other member, and the chairman will be entitled to constitute a single member bench. That is good enough. Then, my lord, the second judgment cited, my lord, in the Delhi High Court, the Goldcroft properties, the lordship will please to come straight away to para 12. In the present case, the petitioner seeks constitution of a bench under 6(7), consisting of 2 members at the adjudicating authority level for the purpose of deciding the confirmation of the impugned provisional attachment. Then, my lord, para 13, a perusal of the said provision would show that it is only at the time of hearing in any matter. My lord, kindly note these words. Each word is important. A perusal of the said provision would show that it is only at the time of hearing in any matter, if the chairperson or a member feels that the matter or the case is of such nature that it ought to be heard by a bench of 2 members, then the chairperson may assign 2 members bench. And this is my submission. The jurisdiction is of the entire body. The chairperson has been given the power to constitute benches. He is to constitute bench, and he is to decide whether there should be a single member or two members. And once he decides that, then I am not entitled to ask question that. And this is exactly what has been said here. But my lord, submission is this: there has to be a bench. There has to be a bench. There cannot be a single person ruling the roost. My lord, he cannot say, I am the sole monarch of all I survey. And that is exactly the position now. One person is, my lord, one person, my lord, the others are not there. He is, my lord, doing whatever he wants to do. My lord, I am not for a moment saying that taking a particular issue or instance, I am not saying that he is biased. I am not, my lord, adverting to other points which had been urged by the trial court, before the trial court. I am submitting on a purely question of law. Can there be a single member bench without the adjudicating authority, without the chairman of the adjudicating authority constituting one? My lord, if that is not so, then, my lord, these judgments, my lord, does not help my learned friend. My lord, and in fact, my lord, it seems that when your lordship looks into the impugned judgment, your lordship kindly sees this impugned judgment. I am submitting to your lordship that kindly see para 25. The learned judge was also not 100% sure. Heard the arguments of both sides. Insofar as the objection as to quorum non-judice is concerned, there are two interpretations possible regarding the provisions of section 6. With that, my lord, preface, he had started this judgment. The two interpretations are possible. One interpretation I have given, another interpretation my learned friend has given. So therefore, my lord, I'm leaving it to your lordship for the purpose of considering. As to my learned friend says, this is not a tribunal. Of course, it is a tribunal. Adjudicating authority is doing what? Discharging the functions of a court of a tribunal. What it is doing is this, my lord. It is deciding the issues which have been entrusted to him. Now, my lord, when it is doing so, it is performing, my lord, judicial, quasi-judicial, administrative functions and discharging all these duties together. So if that is the submission of mine, my lord, if that submission has got any validity, my respectful submission is this, that my learned friend cannot say that this the word the used as tribunal in the Supreme Court meant only the tribunal, the appellate tribunal. No, I am submitting to your lordship, no. L. Chandrakumar's judgment does not confine itself to, my lord, the tribunals only. It, my lord, any adjudicating authority which is, my lord, deciding the fate of an individual citizen has to be, my lord, has to discharge the function judicially. If he does not do so, then, my lord, in my respectful submission, he is not discharging the duties as has been entrusted to him. My lord, these are constitutional, these are constitutional rights of persons are there. What is the dispute now? My lord, there are certain gadgets which have been seized. My client says that have these gadgets, my lord, examined by, well, I tell you, lordship, what is being said. He says, my lord, that these be examined by the expert body, expert, my lord. Yes, my lord, kindly, in fact, my lord, on 10th January 2023, the petition number 2 moved an application before the special CBI judge for appointment of an independent cyber expert of any government agency with a direction upon him to, my lord, to retrieve the contents of those. But this came up before the adjudicating authority. And, my lord, the adjudicating authority decided that. My submission is this, that this is, my lord, and what is a citizen saying? He's saying, yes, you do whatever, you discharge your duties, you have seized these materials. Protect my interest by appointing a cyber expert for the purpose of opening it up and finding out what is inside it. That application is pending before the adjudicating authority. My submission is this: an adjudicating authority without having any judicial background, purely administrative, whether he is entitled to do this. But therefore, I respectfully submit to your lordship that it is not quite এটা দেখেছি আর দেওয়া দরকার নেই। Well, therefore, my lord, I respectfully wind up my submission by saying that the adjudicating authority is has been contemplated by the legislature and my lord as enumerated in section 6. If it is not so, then it's not an adjudicating authority.
Date fixed.
Consists of a chairperson, 2 members.
Hmm.
It is the 2 members. As of now, there is only
এটাতে কি হয়েছে এটা কি আছে?
this is appointment of members qualification. Yes. The bench will be constituted by the chairperson of the jury with 1 or 2 members as the chair. There is a
করো না দেখো।
into it can situation is not as question is minimum that should be 2.
Yes, Mr. Chakraborty, kindly come to page 25, paragraph 65
Of the appeal.
of the application.
My lord, page 25, paragraph
65.
My lord.
You can skip first 4 or 5 sentence lines. Paragraph sentence starting with however in the instant case.
Right.
What is your submission on facts?
Yes. Yes. Yes, my lord, this is their contention.
What is your submission on facts?
On-
Whether it is correct?
Yes.
Actually,
There one member was appointed. The chairperson was appointed. My lord, the adjudicating authority shall be consist of a chairperson and 2 members.
No, what they say is there is only 1 member and he is discharging the functions of the chairperson also.
Yes. Yes, it is a fact. It is a fact. And now, my lord, notifications have been issued for appointment of other 2 members, 1 technical and 1 judicial. Chairperson is functioning alone as adjudicating authority. It is a fact.
But as of now, there are 2 members are not there.
Other 2 members are not there.
But
We have got this notification dated 22nd June,
Last page of the paper book.
the last page of the paper book, if your lordship kindly.
What does that notification say?
And it says-
Print out copy, my lord, only 1 member is appointed.
Only 1 member is
I am
appointed.
also saying the same thing. This is a
Pradeep Kumar
fact. I cannot
Upadhyay,
improve it.
ex-principal advisor, cost, Department of Food and Public Distribution,
So there is
as
a
member
chairman and 1 member.
from the field of finance.
Only 1 member, no chair.
Well, and no chairman.
No, there is chairman. Chairman has been appointed. The same person has been appointed as the chairman, my lord. If my learned friend says today, my lord, the learned friend came up before this honorable court, kindly come to this. Then if my learned friend says this incorrect fact, I have to show.
No. আগে ছিল।
You can,
Kindly-
if I mean,
kindly come to that.
it's quite possible.
Kindly come to the impugned order.
My lord, may I just, my lord,
No, kindly allow.
one thing, my lord,
Kindly
earlier, my
allow
lord,
me.
there was 1 member and the member was the chairperson.
Yes,
And my lord, after the impugned order was passed, chairperson retired from his, demitted from his office. Then my lord, last annexure, my lord, a new member has been appointed.
new
Not that-
chairperson has been appointed.
এটি
I
চেয়ারপারসন
don't know,
বলছেন।
this is I have.
আচ্ছা, সেই নোটিফিকেশন দেখাও না। আমার কাছে যে নোটিফিকেশনটা আছে সেটা তোমায় দেখাচ্ছি।
So as you can say, it is used. What is wrong? The exercise this power. Or
as member লেখা আছে, as chairperson লেখা নেই। তারপর যদি কিছু হয়ে থাকে আমাদের জানার কথা। As member.
No member to be the chairperson of your adjudication.
Last time page of the.
So there is.
কিছু পড়া যাচ্ছে না।
এটা সেজন্য তো প্রিন্ট আউট করে দিচ্ছি।
প্রিন্ট আউট তো judge
হ্যাঁ,
don't say last page, say that this is a print out of the last page. Last page কিছু পড়াই যাচ্ছে না।
সেই জন্য স্যার এটা দিচ্ছি।
সেটা পড়া হলো না।
মানে the impugned order paragraph 29. Impugned order paragraph 29, my lord. My learned senior friend was showing that the judge was saying that there are two interpretations is possible. But the honorable single judge has correctly taken their view also, our view also, and come to the conclusion.
Yes,
Paragraph
that is why I am questioning that.
Hence, on a comprehensive interpretation of section 6, it is clear that not only has the chairperson the discretion to constitution of bench with only one member, but the norm also as per section 6(7) is that the bench will consist of a single member, and only if the case is of critical nature, a bench consisting of two members will assign the hearing.
This is exactly the point.
Now, this is not a case to my humble submission, which is of any critical nature.
They said that it's a single.
I am not for a moment contending before your lordship that single member bench cannot be constituted.
That was
I
the-
say it can be constituted
No,
by
that
my
was
lord the chairman.
No, I think that was the
was
argument
the
in the
argument.
repetition.
My lord.
Here, the
Only-
stand is slightly different.
Yes.
What the case before the learned writ court was that a single member cannot hear.
Yes.
Single member.
Now, the case says of the appellant is, yes, single member can hear, but an adjudicating authority necessarily has to be more than one.
And my lord, the chairman will have to constitute the
Here,
bench.
chairman has
Consisting of
constituted the
Section 3, subsection 3, clause A and B provides two categories.
Right.
Assuming they don't fill up category A, clause B is filled up. Under subsection 4, is there a bar for the central government to notify that very person as a chairperson?
My lord, my submission is this, yes, there is a bar, there will be a bar. Because my lord, it is, what is happening is this.
So then you will be reading something into the provision which is not there. So please see subsection 4,
Your lordship can.
subsection 6. Now the argument appears to be different in this appeal.
Was this point taken
No,
before
it
in
was
the
not.
writ petition?
No,
What has been taken in paragraph 65 of the stay application? Was this point urged before in the writ petition?
In the writ petition?
Yes.
Yeah.
It was from the pleadings in the writ petition that this was the.
I think so, yes,
pleadings.
my lord. Your lordship will kindly take, my lord, the paragraph writ petition, of course. In fact, my lord, writ petition টা কোথায় আছে? My lord, kindly see the prayer at paragraph 43, page 19. In the writ petition.
Page 19.
Prayer B. Declaration that the adjudicating authority in the instant case has not been considered in terms of the mandate of the prevent so and so, or is statutorily incompetent to
The
take
writ
up the
petition
case.
annexed.
Well, writ petition should have been annexed.
You have a copy of the writ petition.
Yes, well, and copy of the writ petition now. Copy of the writ petition আছে তোমার কাছে? But unfortunately, it is not annexed. I looked for it also.
What we want to know is that whether there is any specific pleading apropos this paragraph 65 of the stay
I
application.
am told it is there. I can check it and tell your lordship. I give you lordship.
Because from the argument before the learned single judge, it does not appear to be so. The entire argument was whether it can be heard by a single member bench or not.
My lord,
As it has been recorded by the learned single
Yes.
judge.
That was the argument.
my lord,
And to the deepest respect, my lord, here also the argument.
if my learned friend says so, I shall accept it. Because I was not in the trial court. If my learned friend says that was the argument.
That was the only argument.
Then my lord, I don't controvert that.
If there is a pleading to that effect.
Yes, that is the only thing I shall look into. কোনো আমাদের প্লিডিং কি ছিল?
Sir, ground.
আমি দেখি না দেখি কপি আছে কপি কি পারবে? মানে ground 8 onwards it has been said copy আছে? Well, can you look into the ground 8 onwards? What is not there, I will not argue.
Any with members
8 and 9.
will consider.
But the last person.
Here they say it is running only with one member. And there is a likelihood of bias.
They said
that is of course
but that
I
was
am
not pleaded
This
before.
factual position is not disputed.
No. I'm never disputing. I cannot dispute, Millard, because this is being appointed by the government of India. I am representing the enforcement
yes,
director.
but there is only one person appointed, not
And
the
he-
chairman.
And he is the chairman.
That this is
Correct.
what
We find from the order of the impugned order. They have said it was their contention. It was recorded in the impugned order only.
well, the office order is 22nd June. It says so and so ex-principal advisor cost Department of Food and Public Distribution as member from the field of finance accountancy in the adjudicating authority under the prevention of one. Kindly see, my lord, this is the last annex, but my lord, I don't want your lordship to, my lord, unnecessarily strain your lordship's eyes because the copy is not good. Here, my lord, it as member in the adjudicating authority. And that's all that is there.
Adjudicating authority is the body. That body consists of 3 members. And one the bar under the statute say that all people should receive. Must receive a definition of adjudicating authority means an adjudicating authority appointed under section 6(1). Central government shall by notification appoint an adjudicating authority to exercise jurisdiction. Shall consist of person and 2 members. But their contention should
যেমন শুনেছি আর কি করছে শুনছেই তো judgment লেখা।
adjudicating authority shall consist of a chairman and 2. Because one member shall be a personal species. So the maximum can be 3. One will be accountancy, one will be judicial, and of course the one will definitely appoint 2. Does it mean to say that adjudicating becomes complex? So each shall consist of a yes. You can't refer it to.
সেটাতে কাটাতে চাইছি না বুঝতে পারছি আপনি ঘাটিও না
As it is, yes, it should consist of thing, but that was the Yes.
Well, grateful to your lordship. We have
Order,
troubled
order.
your lordship enough, my lord, on it. Point your lordship will kindly excuse us.
Can you give a copy of that writ petition?
Yes, yes.
Very
yes.
appreciate.
In the course of the day, my lord, I will hand it over. And my lord, আজকে hearing টা যে একটু বলে দিন।
But today the hearing is there.
Probably for the
Before
12th time. it
before
is
the- Yes, yes, very well. I mean, these are prejudicial facts. You are saying so, I am accepting it.
My lord, kindly,
The
allow,
hearing is
kindly
there.
allow the adjudicating authority to conclude the hearing, not to pass any order till your lordship passes any order.
Well, I will respectfully submit to your lordship. Let him not go.
My lord,
the
that
hearing.
will take further more time. Let him conclude the hearing. He will
Seven
not
days
pass
time.
any
So
order.
during the pendency of the writ petition, they had an interim order.
They had no interim order. The adjudicating authority adjourned the hearing from time to time because of the pendency of the writ
You
petition.
do the
Very
same
good.
thing.
Adjourn the
Yes,
matter. I
that
shall
has been
request my
done on the
lordship
last
to adjourn the
No
matter.
order is reserved. The adjudicating authority, they shall defer the hearing till judgment is delivered in this appeal.
Lordship, I am very grateful.
Deeply blessed.
স্যারের কাছ থেকে নিয়ে জেরক্স করে আবার স্যারের
চলো, খুব হয়েছে।
Item number 10.
My lord, I am for the West Bengal Pollution Control Board.
I am for the respondent number 456 from the Union of India.
So Mr. Amitesh Banerjee is appearing for respondent number 3, I suppose. Played by Advocate General, my lord.
This is regarding this packaged drinking water.
Yes. Another, my lord, the petitioner, my lord, has challenged the inaction of state respondents, my lord, to allowing and manufacturing this packaged drinking water without license.
Yes. But that requires the Bureau of Indian Standards.
Yes.
certification. And what was your response?
State has filed a report in form of affidavit that has been served to the other side. They have requested to file exception to that.
But
That
the
has not been.
last occasion, they have said they don't want to file any exception. That is recorded on 31st October. Let us see your.
We have not received any copy of that.
No, they don't want to file. That's what is recorded in 31st October order. Now, you are appearing for which?
I am for the respondent number 3, my lord.
3.
Lord, I am not in the state panel. I am just a junior of Mr. Banerjee.
Where is your report? But of course, report says a lot of checks and balances
Yes,
are there.
steps has been taken.
But how effective it is in
But
its
it is only the
implementation?
report
That is the
from the inspection raids has been conducted and the steps has been taken. It's a report R1. It's a paragraph number
but
12.
some more effective monitoring is required, especially the sachet.
Yes.
Bottled water probably has to have a seal,
Yes.
has to have a label. They can. That is one thing. The sachet water is the main, especially that is distributed in all these functions, festivals, etc. When there is a large crowd. Secondly, the water bottles which are being used are being reused by filling and resealed.
Yes.
So how to prevent that? That is also one of the issues. That's more dangerous than So you can do one thing, you can conduct periodical raids. Wherever there is no BIS certification, you close down the unit. Then let them apply the certification, get the appropriate approval from the Pollution Control Board, then they can start off.
Yes, Lord.
By this public interest petition, the petitioner has highlighted a very important issue with regard to safety of the packaged drinking water. Petitioner seeks for issuance of a direction upon the respondents to create a task force which shall coordinate among the various departments and constitute special crack units which will undertake surprise checks at various levels of manufacturers of packaged drinking water and initiate strict action in terms of the provisions contained under the BIS Act, FSSA and IPC and other statutes. Pursuant to the directions issued by this court earlier, the third respondent, namely the Special Secretary of the Department of Health and Family Welfare, Government of West Bengal, comma, the respondent number 3 has filed a report in the form of an affidavit. On perusal of the said report, we find that a special task force has been constituted under the Department of Consumer Affairs to monitor the activity of various illegal trade practices, including that of illegal packaged drinking water. The steps taken by the state level advisory committee, headed by the Chief Secretary, Government of West Bengal, have also been mentioned in the report. It is stated that from 2019 till 31/12/2021, totally 340 samples were submitted to the state laboratories and 280 samples have been tested. That apart, large number of awareness camps are being organized by the food safety officers for licensing and /or registration of food business operators, so that those willing to carry on the business of packaged drinking water may do so in a proper manner. With regard to the criminal prosecution to be initiated against the violators, it is submitted that somewhere they stated
Small indulgence in paragraph number 12, which says that approximately 413 inspection have been conducted.
yes,
by
that will refer.
Yes,
Regarding the IPC offenses, I saw somewhere that you had stated. Yes, paragraph 7. With regard to criminal prosecution, it is stated that the department that the same will fall within the jurisdiction of the police department. And during joint raids against the food business operators of packaged drinking water, the food safety officers are present as a member of the joint raid team requisitioned by the district enforcement branch within bracket DEB, and seizure has been effected and cases have been registered under the relevant provisions of the Indian Penal Code by the DEB. Further, it is stated that the food safety officers and district food safety inspecting officers conduct raids/inspections along with the enforcement department, and approximately 413 inspections have been conducted by the officers from 2012 till the date of filing the report, and 85 plants were closed. The report submitted by the respondent number 3 would prima facie show that there is a monitoring mechanism to ensure that nobody manufactures packaged drinking water without the requisite licenses. However, the problem is not a one-day affair. It requires continuous and vigilant monitoring of all the packaged drinking water manufacturers. The court would suggest that a database be created by the health department of the state of West Bengal, where all the registered manufacturers can be enlisted, and a caution notice can be issued stating that without obtaining the requisite licenses, no manufacturing no unit can manufacture, can produce packaged drinking water. That apart, the not that apart. Apart from keeping apart from continuous monitoring, the public may also be sensitized by the health department by handing over leaflets and erecting boards during festival seasons, warning the general public not to drink water which are packed, which do not display the requisite approvals and permissions which are mandatory in character. This court trusts that the monitoring mechanism is strengthened and it shall be a continuous monitoring be done so that the safety and the health of the general public are protected. With the above observation, writ petition stands disposed of. Next.
Grateful. Item number 11.
Lordship, I beg to appear on behalf of the respondent number 8.
Respondent number 8, okay. State you are filing a report.
Yes.
Petitioner counsel is not there. You are for the petitioner.
No, I am for the respondent number 8. We were directed to file a affidavit of opposition, Your Lordship.
Our report says without having conversion, land pond was filled up and subsequently construction was made. And we have issued the notice under section 4C subsection 5.
Very good. You proceed pursuant to the notice.
My lord, may I be allowed to use an exception to the report because
No. Why exception? You file your objection to the 4C notice.
Oh, yes, my lord.
The petitioner has filed this writ petition alleging that a pond measuring about 29 decimals comprised in RS gag number so and so. Sorry, this is order dated 21. So and so has been filled up by the 8th respondent. And in about 25% of the area of said pond, illegal construction has been put up. The court, by order dated 21/11/2022, directed the state to file a report. Today, a report has been filed in the form of an affidavit on behalf of the respondent 3 to 5. The operative portion of the report reads as follows. Paragraph number 2, on page 7. Page 2.
So, the affidavit copy to that?
From here.
Service for the moment. Extra copy later.
Thus, it is seen that the authorities have already initiated action and notice has been issued under section 4C within bracket 5 of the WBLR Act 1955. In the light of the same, we direct the authority to proceed with the notice after giving an opportunity to the 8th respondent to file the response, and final orders be passed on merits and accordance with the law within a period of 12 weeks from the date on which the reply is filed by the 8th respondent to the notice issued under section 4 capital C5. Ultimately, if it is found that the entire filling up of the pond is unauthorized, action should be taken to remove the offending construction and restore the pond to the original position, and cost of such restoration be recovered from the 8th respondent.
And in the event, if authorities come to the conclusion that they have done this, they are kindly direct them to restore it.
If they don't restore it, you do it at their cost. Next.
Item number 12.
It is our application, my lord. Here on the vested land, my lord, the
respondent number 5, my lord.
Lordship will kindly, these are the affidavit of service to all the parties.
Respondents have been served.
My lord, I am for the state respondents.
I am for the private respondent.
And any report was called for? No.
No, my lord.
Your lordship will
Lordship, my
kindly
lord,
see at page 26, just page 26, my lord, that there is the self-admission on the part of the governmental missionaries. My lord, at page 26 P4, there your lordship will kindly see, it is the third paragraph. LR plot number 47 and 288 are vested land under Khotiar number 1, on which 0.0350 acres and 0.015 acres were respectively occupied by Amantran apartments, means by the private respondents, by constructing high drain and concrete road. Therefore, if your lordship will kindly take pain to go through this very particular portion at page 26, annexure P4, then your lordship, it is the categorical statement, it is the self-admission on the part of the governmental machineries, governmental authorities, that it has been occupied by the Amantran apartment. That is the private builder or the constructor, means the promoter. And they have constructed high drain and concrete road. It's purely within the domain of the governmental machinery to concrete, means rather concrete road or high drain, it is within the power and within the prerogative of the state authorities.
No, uh,
How they can encroach it?
No,
Therefore,
after this, what action was taken?
no action has been taken till to date, and your lordship, at least my lord, your lordship will kindly see that they have almost completed it. Not only that, there's a report, 5-story building has already been completed, and it has been, my lord, it is, though it is written in a Bengali paper, Anandbajar Putrika, at page 45, that it is, they have stated even the water connection has been given as per the Supreme Court's order, means in general way, Supreme Court has given not in this particular case, but the Supreme Court's order in the case, in another case, or rather in almost all cases, it is that a man who already remains here, then he should not be deprived of. But in other apartments case, your lordship is well aware, and also in series of cases, if there is a already, means rather if a person who has got no local standard to stay any longer for a particular premises, he is not entitled to get any electricity, as well as under section 43 of the Indian Electricity Act, the latest version of the Hon'ble Supreme Court is, as well as the means light also and water also cannot be given. My lord, at this juncture, what is our prayer, my lord? Let there should not be any third party, means interest will be, at least will be there. That is the first purpose.
No.
Second purpose is, my lord.
There is a drain and a concrete road.
Yes.
Now, after the district magistrate has been informed by the BLLR, saying that what action the state has taken.
Yes. My lord, subject to correction, my lord, the writ petitioner, my lord, has filed a petition under 144. My lord, certain orders have been passed. Now, my lord, he has approached this public interest litigation. My lord, be that as it may, there is a representation made before the district magistrate on 20th December 2022, that is at P7. So your lordship may kindly direct the district magistrate to initiate appropriate steps.
This will not serve the purpose.
Now, my lord,
But BLLR is already.
now, my lord, unless subject
why
to.
he should trigger the.
Now, my lord, unless subject to correction, lordship kindly appreciate one thing. Without hearing all the parties, my lord, the petitioners and the person interested, as well as Asansol Durgapur Development Authority.
Yes, all have been notified, all have
magistrate,
been given since 20.
But I am appearing for the Hon'ble Durgapur Development Authority.
all the, my lord,
No,
Illegal.
they have not granted any sanction in respect of the subject property.
Pardon? Who is?
You are for the fifth respondent.
My lord, the Asansol Durgapur Development Authority. My lord, lordship will find at page number 19 of the writ petition, my lord, that sanction was granted in respect of plot number 51. But the petitioner's case that encroachment has occurred in plot number 46. So as far as ADDA is concerned, we have not.
Petitioner's case. It is the case of the block land and land reforms officer. He says that.
Correct.
Yes. So
page 46.
We have not granted any sanction as far as plot number 46 is concerned.
Yes, my lord, lordship kindly direct the district magistrate.
No, of course, after notice to the petitioner,
my lord,
after notice to the fifth respondent,
and
that is Asansol,
yes,
as well as the private respondent.
My lord.
The petitioner has
And
filed
also
this
the petitioner must also be represented, and my lord, your lordship will not dispose of the matter, but my lord,
Kindly.
if latest status report be brought before your
cannot
lordship.
say you cannot say what order we have to.
No,
put.
no, that I'm not saying.
File an appeal.
No, that I'm not saying. My lord,
That
if-
is the discretion.
no,
of the court.
my lord,
That's the discretion
my
of
lord,
the court.
subject to your lordship's correction, but I am saying,
Personal
my lord,
interest.
whether your lordship, my lord, is completing.
You please hear the matter.
My
Hear
lord,
the-
my lord, that means
By
that
this
the late
writ
here be
petition,
something status report
filed-
brought,
filed-
how
filed-
they have tackled with the
filed
situation.
as a public interest writ petition, the petitioner point out, the petitioner seeks for a direction upon the second respondent to demolish an illegal construction put up in a land which is a vested
Amantran
land,
apartment,
which is a vested land.
government vested land.
There appears to be no dispute on facts, as could be seen from the proceedings of the Block Land and Land Reforms Officer Fardipur-Durgapur dated 5/7/2022, which is quoted here in below. Sir, this page number 26, sir, from here to here. The reading of the above would clearly show that LR plot number 47 and 288 are vested land under Keita number 1, on which 0.0350 acres and 0.015 acres have been occupied by the by constructing high drain and concrete road. Though such information was furnished to the district magistrate as early as on 5/7/2022, followed by representation given by the petitioner on 25/11/2022, till date the district magistrate has not initiated action. Considering the fact that the appropriate authority, namely the Block Land and Land Reforms Officer, has come to the conclusion that a vested land has been encroached upon by the 12th respondent and a construction of a high drain and concrete road has been made, action has to be initiated against such illegal construction. Therefore, we direct the second respondent to immediately issue notice to the private respondents, namely respondents 12 to 15, as well as to the writ petitioner, as also the Asansol Durgapur Development Authority. And in the presence of all parties, a site inspection should be conducted, and thereafter the private respondents, namely 12 to 15, can be permitted to submit their reply, and after which action should be initiated in accordance with the law. This direction should be complied with within a period of 6 weeks from the date of receipt of the server copy of this order. Needless to state that if ultimately the district collector comes to the conclusion that there is illegal construction in a vested land, the respondents 12 to 15 should be granted 15 days time to remove the offending illegal construction, failing which the construction shall be removed departmentally and the cost shall be recovered from the respondents 12 to 15. Next.
The writ petition is disposed of, my lord? I'm deeply obliged.
Yes.
Item number 13.
Lord, I am for the state.
For opening of a hospital, everything is ready.
Affidavit of service.
You are for the petitioner. Prayer is for opening in a hospital.
Hospital raised by my fund of the people of the area, my lord. So my lord, now they are my lord closing and my lord trying to sell the same to the my lord other person.
Who's going to close? Who's closing?
My lord, kindly see my respondent number 12, my lord.
No, who has
The petitioner before your lordship, Malad is a local people.
Yes, my lord.
Who said that some Malad NGO, Malad in the name of Malad the
Southern-
SHI.
Oh, it's not a government hospital.
Yes, Malad.
It is not a government hospital.
No, Malad.
Not a
Malad, what happens, Malad?
What to, how we
They are,
can,
they are saying, malad, they are criminally intimidating. But after the malad, their malad objection, not one inquiry has been done by the inquiry officer, and malad say that neither the petitioner nor the local people had the criminally intimidating for taking money.
all right,
And malad, this
that is
a
one
report.
aspect.
Malad,
What,
this is a
what
report.
about that hospital? If suppose they close the hospital,
Probably malad, they are malad.
but how we can compel a private entity saying that you should not close down? It
Malad,
is
kindly see page number 49, Malad.
49.
49. Malad, we
This is the
represented to the
report from
Register of
the.
Farm, Malad. He relegated the same to the Joint Registrar Authority, Malad. Kindly see page 49.
No, it may be a registered society, sir, but still it is a private entity. How we can issue a mandamus saying that you have to keep the facility open?
But my lord, that fund, my lord,
Yes.
My lord, in the rural area of Malda, there is dearth of medical facilities.
Correct.
Accordingly, my lord, a medical center was at the sponsorship of the villagers also. My lord, the medical center was opened there. My lord, we donate, the villagers even donated land and other facilities. My lord, all on side, right from 2006, it is the only, my lord, source of our recovery of from any illness and protection. In 2006, it was established. In 2022, my lord, the organizer of the said hospital, my lord, are wanting to sell it out to the third party and for the purpose of different business to be carried on over there.
But the land was donated by the villagers.
Land was not, land was purchased by them from the villagers. We allowed to the purchase. Allowed the, we donated our fund. We have made a representation to the district magistrate also. Let him take a decision. Let him take a decision for our health purpose, medical purpose.
He can prevail upon the society saying that please continue the facility.
No, we cannot force anyone, my lord. We cannot, but if the alternative arrangement can be done for the villagers, my lord, let the medical center may continue for the time being.
Is aggrieved by a decision taken by a 12th respondent, which is a society registered under the provisions of the Societies Registration Act on the file of the Joint Registrar, DPLO Malda. The 12th respondent has been running a medical facility in the said area, and according to the petitioner, it is the only facility which is available in the vicinity for the public to be treated for their ailments. The allegation is that the 12th respondent has taken a decision to close down the facility and use the building for some other purpose. In this regard, a representation has been given to the district magistrate. It is not in dispute that the 12th respondent is a private organization who had purchased the land and established the medical facility. Therefore, neither the court nor the authorities can compel the 12th respondent to continue to have the facility in place, as it will be well open to the organization to take a decision in accordance with their bylaws if it is not feasible to run the facility. Nevertheless, this court will take note of the submission made by the learned advocate for the petitioner that in the near vicinity there is no government hospital or primary health center providing healthcare facility for the public, and therefore the state should intervene and prevail upon the 12th respondent not to disband the medical facility which had been established by them. At best, the attempt of the third respondent, namely the district magistrate Malda, can be only recommendatory, and the 12th respondent cannot be compelled to keep the facility in operation. In any event, since the representation is pending before the district magistrate, we direct the district magistrate to consider the representation submitted by the petitioners on.
Well, that was received by the DM, dated September 13 September 2022.
13 September 2022, and pass appropriate orders on merits and in accordance with the law. In order to facilitate the compliance of this direction, the petitioner is directed to forward a copy of the representation along with a copy of this order and and submit the same in the office of the district magistrate, Malda. The direction be complied with as expeditiously as possible. Next.
Deeply obliged, grateful to your lordship.
Item number 14 to 18.
14 to 18, my lord, kindly recall, this is relating to overcrowding in different jail, dearth
Lord,
of jail staff, and my lord, the person who died in jail, unnatural death, my lord, the compensation part. My lord, the report has been furnished by the state authority. The last occasion, my lord.
Lord, I appear for the Registrar General of this Hon'ble Court.
Kindly permit me, I can show certain things, my lord, which is coming out from the report, my lord. And my lord, at least on to 88 persons are languishing in jail.
No, at least you can put it in a bullet point form so that.
My lord, I've done it for your lordships. My lord, I think there's been a fair disclosure, my lord, from the state. My lord, there are several faults which need curing, but your lordships wanted it, my lord, in chart form. So, my lord, I have, my lord, last occasion, my lord, filed, my lord, in chart form. Kindly take your lordship's last order, my lord, and we can go, my lord, one by one. It'll take 5 minutes. What? My lord, 10th of April, kindly take, my lord, 10th of April, order, my lord.
Yes, 10th of April order.
My lord, kindly see, my lord, the lordship refers to, my lord, 4 issues in paragraph 2. The Honorable Supreme Court in the case of so-and-so pointed out 4 issues, namely overcrowding in prisons, unnatural death of prisoners, gross inadequacy of staff, and available staff being untrained or inadequately trained. These were the 4 issues which were, my lord, pointed out by the Supreme Court.
Yes.
Now, my lord, kindly come to paragraph 3. Therefore, the tabulated report, the tabulated report to be submitted by the state should cover these 4 issues pointed out by the Supreme Court. Now, my lord, kindly take, my lord, module, my lord, report module A, my lord. That's the. Now, my lord, kindly read this, my lord, with, my lord, paragraph 4 and 8 of your lordship's order. Apart from that, the report should disclose as to how many are under trial prisoners, how many are convicted prisoners, the number of male and female prisoners, prisoners who are confined to correctional homes, having been charged of offences under the Narcotic and Psychotropic Substances Act, those have been charged of illegal immigration, and the number of prisoners who are of foreign origin. The report should also furnish required information about prisoners who have been granted bail, but being unable to satisfy the conditions of bail are still languishing in the prison. And, my lord, kindly come to paragraph, my lord, 4 or paragraph 8. My lord, kindly take 8. As suggested by the learned advocate intervener, the information to be submitted by the state shall also give details of convicts in the death row, which whether they are in solitary confinement or not. The information to be disclosed shall also mention about the number of cases in which appeals are pending before this court, either at the instance of the petitioner or by the de facto complainant. So module A, my lord, covers, my lord, the point raised in para 2, my lord, 1, 2.1, para 4 and para 8. And your lordship's paragraph 7 had stated, after the information are furnished, court will deal with various issues raised in public in seriatim 1 by. Now, my lord, kindly have a look. My lord, this is, my lord, the, my lord, index at page 2, my lord, of the module. Your lordships, my lord, turn over to page 3.
Yes.
My lord, I must tell your lordships, this report was prepared, my lord, as on 1st of April 2023, which had been, my lord, your lordship will find that right at the top,
Yes,
my lord.
1/4/20.
I hope, my lord, we have the colors, my lord, also in your lordships. My lord, I have to get people to take pride in what they do also. That is important. Now, my lord, kindly see, as on 1st April, combined population of correctional homes stood at 2751,519 under trial convict, John Khalash, condemned prisoners and children against registered capacity of strength. This is the overall picture, which is 126.73%. Breakup of the total population is enumerated. So, my lord, under trials, male, female, other. Lordship, kindly see the column, my lord, under trials, convicts, male, female, other. John Khalash, so-and-so, condemned, so-and-so, children. Then correctional wise, my lord, home, my lord, I've also given, my lord, the, my lord, breakup at page 4, correctional home wise. My lord, some are overcrowded, some are not. This gives, my lord, the total picture. The first sheet at page 3, page 4, my lord, is, my lord, my lord. The other day, your lordships wanted to know, my lord, which was the worst to send, my lord, one of the countries. That was, my lord, Malda, which I had pointed out to you. Because, my lord, I had gone through this. So, my lord, I remembered.
So Malda is the.
Malda is the worst, my lord, in terms of, my lord. Now, my lord, kindly come to, my lord, page 5. My lord, inmates charged as per provisions of Narcotics, Drugs and Psychotropic Substances Act. My lord, again the same breakup. My lord, under trials, convicts, John Khalash, correctional home-wise breakup is at page 6. Then, my lord, page 7, my lord, gives, my lord, foreign origin who have been charged for offences related to so-and-so. And, my lord, your lordship will find, my lord, these are of foreign origin. My lord, and this is the next chart is, my lord, total. My lord, inmates charged for offences relating to illegal immigration. Not necessarily, my lord, of foreign origin. Or not necessary, my lord, under, my lord.
Foreigners Act.
Yes. My lord, first is not necessary under Foreigners Act. The rest, next is, my lord, under Foreigners Act. Then, my lord, correctional home-wise breakup. Pages, my lord, 8, 9 and 10. Then, my lord, page 10, 8 and 9. Page 10, my lord, are bail, but unable to satisfy bail conditions.
Can we do something for that 88 now?
Yes, please, my lord, kindly do that. My lord, not only that, I've also.
Because if the bail bond, if they don't have anybody to.
My lord, I leave it to your lordship, my lord, whatever. But, my lord, when they come out of the correctional home, my lord, they also need to be taken, my lord, care of, my lord.
Rehabilitation,
my lord,
where they will go.
Yes. My lord, this is, my lord.
Please come to page 11. Bail bond 5,000 with 2 sureties.
Yes.
He couldn't furnish. 3,000, 2,000, 3,000, 3,000. Unable to pay bail amount.
My lord, that's what I said, my lord. I leave that, my lord, entirely, my lord, to your.
But how in a PIL to say that the court will release him without. There was some precedents where some bond was furnished instead of cash payment. Can be substituted by something else. I don't know where I read that judgment. It's a Supreme Court order. But of course, cases where Arms Act is out
Yes,
there.
my lord, there are, my lord, some, my lord, we'll have to look at the nature of, my lord, the offense.
302.
Yes. My lord, we'll have to look at also, my lord, the nature of the offense.
What is your suggestion?
Suggestion is that, my lord, there is the district legal aid committee in all the district. Let them take the charge, my lord, to release them.
They can file an application before the ACGM to relax the condition.
But the thing remains unchanged, my lord. It's difficult that, my lord, such a, my lord, unfortunate person for non-payment of 500 rupees, they are languishing in jail, my lord.
Don't argue this case as if you are arguing an appeal. You assist, you also give some pro bono service. We'll refer a few cases. But how do you modify a judicial order? In a PIL, we can't say release everybody. So therefore, the suggestion is through the DLSA, they can approach the DLSA. I mean, the DLSA PLBs can go to the prison and get those details. Probably file an application for modification.
My lord, the orders of High Court also.
If somebody can furnish this list to the respective DLSS, we can issue direction. But it will be difficult.
That we can do. The learned Registrar General can.
No.
We are here, my lord, to take the responsibility. We are intervener, my lord, we are here to take the responsibility to
No.
inform the DLSA.
That is, let us say Chandan Nagar PS.
Yes, my lord.
It has to go
Hooghly district.
to Hooghly district.
Yes, my lord.
So somebody should be able to pick up that data, and it can be in soft form, it can be forwarded to the
My lord,
respective.
kindly keep it on Monday, my lord. By that, as far as this sheet is concerned, my lord, I'll.
This is first we'll
Yes.
do something about it.
And SLSA is here, my lord.
I'm appearing for the state
Legal, sir.
Yes, sir.
The one submission I make, my lord, kindly consider section 362 of the CRPC. Because once the judgment has been passed by a criminal court, it cannot be altered. Until and unless it's a typographical error or
No,
mathematical.
this is a bail order. It's a bail order.
My lord, but subject to correction, maybe these are post conviction or no, continue.
Under trial.
Oh, under trial.
Under
Yes,
trial.
then my lord, it can, then my lord, the bail condition can be, and
All right. Suppose this list is given to SLSA.
my lord,
Can you pick up those cases and distribute it to all DLSAs?
my lord, I kindly passes a direction to that effect so that I can also communicate to SLSA and the matter can
And
be
if you can
streamlined.
do one thing, sir, whoever has prepared this report, soft copy may be given to DLSA.
My lord,
SLSA.
SLSA.
My lord, I think, my lord,
I have a hard copy.
my lord, I've served.
Soft copy.
Oh, very.
So
That would be easy to communicate.
yes. So what they need to do is paste it in a file, a standard letter format.
For
to the
each
concerned,
state, my lord, we will, each district.
Lord,
Give a
the,
soft copy.
the email ID is required to be given.
I shall communicate. My lord, though Mr. Kollol Mondol is appearing in item number 14, I am in item number 15,
Very
but I shall
Both of
take,
you.
I shall take.
So what is module B?
My lord, module B, my lord, deals with,
Unnatural death.
my lord, unnatural death of prisoners.
First, we will finish on this.
Yes, my lord, there is more in module A, my lord. I wanted to show your lordships.
What else is there?
My lord, the appeals, my lord, which are, my lord, pending. My lord, where, my lord, under, my lord,
Page number?
my lord, page 16.
As per the reports of correctional so and so, there are totally 15 condemned persons. 13 inmates are pending before the High Court at Calcutta. And those 13 appeals,
My lord, page 17.
is it been filed through legal aid or private parties?
My lord,
Private
that,
counsel. Criminal appeal number not available, not available, not available.
my lord, we tried, my lord, we have not been able to.
Yeah. And 1, 2, 3.
In fact, my lord, legal aid could probably have all these details.
High Court Legal Services Committee will have it.
That's
But provided the appeal was filed through them. If it had been filed through a private advocate.
Then, my lord.
So for today,
Right.
we'll take care of this 80.
Right.
In terms of the.
Only one indulgence, lordship. So for A is concerned, we want to add something. If this honorable court kindly permit us on the next day, we will come back, my lord, along with.
We'll see that. In terms of the directions issued by this court on 10th April 2023, the state has filed a set of comprehensive reports which have been which are in the form of a report module, capital A to G. The learned Advocate General appearing for the state submitted that in paragraph 2 of the order dated 10/4/2023, the court had referred to the decision of the Honorable Supreme Court and pointing out 4 issues, namely 1, overcrowding in prisons, 2, unnatural death of prisoners, 3, gross inadequacy of staff, and 4, available staff being untrained or inadequately trained. It is submitted that apart from the above 4 issues, in paragraph 4 of the order dated 10th April 2023, the court had called for, the court had directed the data regarding under trial prisoners to be mentioned. And in paragraph 8, with regard to the details of convicts in the death row. Since the report is exhaustive, we have to proceed in phases. From the report module A, which covers the directions issued by this court in paragraphs 2 within bracket 1, 4 and 8, we first take up for consideration the issue relating to inmates still languishing in correctional homes after being granted bail, as they are unable to satisfy the bail conditions of bail. Full stop. A list of 88 such inmates has been furnished in a tabulated form. On a cursory perusal of the details furnished in the tabulated form, in majority of cases, the bail bond, the majority of the cases, the court has imposed, the court has granted bail subject to the accused furnishing a bail bond of a minimum of ₹1,000 to ₹5,000. Of course, there are certain exceptional cases where the High Court has passed an order granting bail subject to executing a bail bond for ₹10 lakhs and 2 sureties of like amount, etc. In cases where the inmates are in an economically very poor state, unable to even furnish a bail bond for ₹1,000 or 2,000 or 3,000, they can be extended legally and through the District Legal Services Authority and the legal aid defense counsels who have been appointed in 10 such districts in the state of West Bengal, and in the other districts, the panel lawyers of the DLSAs can examine the cases, can examine case by case, and if there is an avenue for, and if it is a genuine matter, and there is an avenue for modifying the conditions while granting bail, appropriate applications can be filed before the concerned court. In order to effectuate such process, we direct the respondent state to furnish a soft copy of the details of the prisoners who have been granted bail but not being able to satisfy the conditions of bail and still languishing in the prison as on 15/4/2023 or up to date, if feasible, within bracket if feasible, to the member secretary of the State Legal Services Authority. Upon receiving the data, the member secretary of State Legal Services Authority shall forward the data to the respective district legal services authorities, who shall examine case by case and if deemed appropriate, necessary application be moved through the District Legal Services Authority before the concerned court for modification of the bail condition. Needless to state, it is for the court to take a decision as and when such application is filed, and there is no direction issued by this court as to what is the nature of the order to be passed by the concerned court. Since it is exclusively within the domain of the concerned court to pass orders on merits and in accordance with the law. The court will, in this regard, the State Legal Services Authority of West Bengal shall take necessary steps, preferably within a period of 4 weeks from date, from the date on which the data is furnished in soft form to the SLSA WB. And the court will and on the next hearing date, a brief report may be submitted by the SLSA as to how the matter has progressed.
My lord, two cases are cases of, my lord, conviction. And then, my lord, High Court, my lord, they're no longer, they're not under trial. But, my lord, there are two cases and the orders were passed by the High Court.
This direction, however, will not apply to cases where the accused have already been convicted and orders have been passed by this court, either granting bail passed by this court, granting bail subject to conditions. So the
It's
report
item 8 and 37, my lord, of the list.
namely item 8 and 37 in the list furnished in a
Module A.
tabulated form in report module A. The other report modules will be considered on the next hearing date. Sir, you also give your feedback. Sir, you also extend you go through this and then. So give a date.
But that liberty may kindly be recorded, my lord.
Yes, sir, not required, sir. You are here day in and day out, you are appearing.
Yeah.
Give a date after 5 years. List on so and so.
Other matters জন্য
Top of it, write the case number. Otherwise, that file will go to this module. Is given in that yellow file, WPA number so and so. You write it. Yes.
But for others report, my lord, let it be listed.
No, one by one we'll do it. In the meantime, you please study.
No, but the overcrowding issue is alarming. In Malda, 236%, my lord. Alarming issue. But that is to be taken into consideration and early opportunity.
I came to know in that district court complex or something, there is a lockup room. There is no ventilation.
Not safe.
And normally 40 people are put inside and they are fighting inside. Some report you can take.
Well, that is why, my lord, we are praying, let it date be fixed meanwhile, my lord.
With regard to the overcrowding in prisons, we have perused the data and we find that certain correctional homes, the number of prisoners are large in number. The appropriate authority of the state may examine this aspect and also explore as to whether the prisoners can be relocated to other correctional homes which are yet to achieve the optimum capacity.
Or under trial review committee is there in each and every district, my lord. That review committee may sit and, my lord, to consider whether some release is required to be made.
Parallelly, the under trial review committee shall also look into the report and examine and suggest ways and means to reduce
within a specified time, my lord. Within a specified time.
Those who have already crossed 14 years, my lord, because of Supreme Court order, my lord, they may be, my lord, that release.
No.
Because of other state, in other state, that after 14, everybody has been, my lord, released. You know, that Prime Minister, my lord, that Rajiv Gandhi was assassinated. Those perpetrators also released.
State sentencing review board is also there, not regularly functioning, my lord. That being the situation, that is the main reason of overcrowding, my lord.
My lord, may I submit this? My lord, as far as my information goes, in the state of West Bengal, for keeping transgender persons,
there's no
nothing. So a trans woman is kept in male prisons, where she's extremely vulnerable.
The learned advocate appearing for the State Legal Services Authority of West Bengal has highlighted a very important and a serious issue with regard to separate correctional homes or separate area in a correctional home for transgender persons. The state shall submit a report in this regard as to how the said issue can be addressed.
So for under trial review committee is concerned, direction may kindly be given the district judge, my lord. Otherwise, my lord, nothing will happen. After on the next occasion, things shall remain.
Review committee. The district judges of the district shall monitor the progress of the matter before the under trial review committee. Yes.
Original side daily list item number 1.
My lord, we are led by Mr. Onindo Mitro. My lord, he's on his legs. I need a short passover, my lord.
Item number 2.
My lord.
Well,
Victor.
May it please the Lordship, my lord. That yesterday I cited a judgment of Supreme Court that was again considered by another division bench. And that judgment may I only place. The judges were, Justice Gokhale was common in both the benches. First judgment we have cited, that is by Justice Gokhale sitting with Justice Chalomeshwar. Second time, that judgment itself was, challenged before division bench of Justice Gokhale sitting with Justice Joseph. That is, that is reported in same volume, both of AIR 2014 Supreme Court 1602.
Enter equal citation of 2014-13 SEC.
Actually. Acha, band box.
Band box. Yeah. Dörsak mı da? Dörsak mı diye çok. Ona kadar. O beni koyuyor. Buraya. Paragraph 4 of the judgment, my lord, can listen. The case of the appellant, page 1602 of AIR, is also reported in SCC also. May I, Miller, please, paragraph 4. The case of the appellant is that the appellant has been occupying these premises right from 26 March 1952, and the respondent bank became owner of this property only on 31st December 1978. These were some initial notices issued to the appellant to vacate the premises. But ultimately, it is a notice dated 15/11/1999 with which we are concerned in the present matter. It was a notice issued by invoking provision of Section 106 of Transfer Property Act. This was followed by the proceeding to evict the appellant, which has led to the eviction order passed by the estate officer, which has been confirmed as stated above all throughout. Mr. Raval submits that the appellant has raised the point of not being covered under Public Premises Act 1971 at all stages, at all stages. He has drawn our attention to the order passed by the estate officer, where it has been recorded that the appellant canvassed the appellant's tenancy continued under the protection of Delhi Rent Control Act, and the respondent were not capable of terminating a tenancy by mere service of the notice. That submission was specifically rejected by estate officer by relying upon judgment of Ashoka Marketing, 1994 SCC 406. Mr. Rawal submitted the plea was restricted before the, reiterated before the district judge and also reflected in paragraph 5 of the order of district judge. Thereafter, the plea has been raised before the learned single judge and also in the special petition before this court. Mr. Rawal has drawn the attention of this court to the judgment in the case of the Subhasi profile, which you have cited yesterday, Milo. In this judgment, in this judgment to which one of us was a party. This court has held that the Public Premises Act cannot apply to premises where occupation had come, occupants had come in possession thereof prior to the application of the Act. That is prior to 16 September 1958. In the circumstances, Mr. Rawal submits that all these orders should be set aside. The appeal should be allowed and the eviction proceedings should be dismissed. On the other hand, Mr. Vikas Singh, learned counsel, appearing for the respondent bank, that the appellant had raised at an intermediate stage, the plea of not being covered and by the public mutual and has subsequently dropped the plea. They had taken relied upon guidelines and therefore the plea which sought to be raised at a second stage cannot be allowed to be raised. It can be allowed to be raised at this stage, allowed to be raised on the ground of res judicata as well as constructive res judicata. As far as this objection, Mr. Vikas Singh is concerned, it has concerned, as far as the plea raised, Mr. Rawal, is based on legal submissions. We would not like to the appellant to be denied the opportunity of raising the legal plea, and therefore we do not accept or not to same making, my lord. This is what we have raised now before lordship, a pure legal plea. Therefore, allow us to raise. There are two other submissions raised by Mr. Vikas Singh. Firstly, he drew attention to the fact that Ashoka Marketing, there were two properties involved. Namely, one was Ashoka Marketing Limited, second one Messrs. Jain Service Limited, South Jain Limited. Both parties were occupying the premises since 1/7/1958. That is prior to the date when the Public Premises Act became applicable. And in spite of that, their submissions have been rejected by the Constitution Bench. This being the position, in his submission, the view taken by the bench of two judges, in the case Subhas Profile, which I may not cited yesterday, is erroneous. We have noted this submission of Mr. Vikas Singh in paragraph 47 of judgment in the case of Subhas Profile. This court has referred to the judgment in the case of Jain Ink Manufacturing Company, 1984, and has observed that the issue of protection under a welfare legislation being available to the tenant prior to the premises becoming public premises. And the issue of the retrospectivity was not under consideration before the court in Jain Ink Manufacturing Company Limited. The same hold goods for the judgment rendered in Ashoka Marketing Limited. And that being so, since those aspects were not gone into in the judgment of Ashoka Marketing, that this court has examined them in the case of Subhas Profile. This court has specifically observed in paragraph 50 thereof that for the moment, this court was not taking any different position from the position in Ashoka Marketing. In fact, that what was done was to clarify that the Public Premises Act will apply only in certain circumstances. That being so, the submission of Mr. Vikas Singh cannot be accepted. He then referred to a judgment of another constitution bench, Kaisari Hind, versus in 2002, volume 8 SCC, paragraph number given. Paragraph 40 is quoted. Once PP Eviction Act is enacted, then the Bombay Rent Act would not prevail, with the repugnancy between the PP Act, between it and PP Act. To the extent of repugnancy, state law would be void under Article 254(1), and the law made by Parliament would prevail. Admittedly, the duration of the Bombay Rent Act was extended up to 1973 by Maharashtra Act of 1970. Result would be, from the date of coming into force of PP Eviction Act, Bombay Rent Act where properties of the government and government companies would be inoperative. For this purpose, language of Article 254(1) is unambiguous and specifically provides that if any provision of law made by legislation state is repugnant to a provision of the law made by Parliament, then the law made by Parliament, whether passed before or after the law made by state legislature, would prevail. It also makes it clear that law made by the legislature, as seen from the paragraph 40 quoted above, the judgment clearly says the Bombay Rent Act would not prevail, with the repugnancy between it and the Public Eviction Act. That aspect has not been contradicted in Subhas Popel's case. It also relies upon a judgment in Ashoka Marketing, Supra, which says that the Public Premises Act as well as the state rent control law are both referable to entries in concurrent list, and they operate in their own field. It is only in the area of its own that the State Rent Control Act applies, and in its own name, in its own time frame. The judgment in Dr. Profil's case accepts that the Public Premises Act will prevail over the Bombay Rent Act to the extent of repugnancy for eviction of unauthorized tenancies and for collection of areas of rent, but not prior to 16/9/1958, when the Public Premises Act became applicable. Paragraph 42-65 relied upon also both do not deal with the aspect of retrospectivity and being protected under welfare legislation. That being so, it is not possible to accept Mr. Vikas. For the reasons stated above, we allow the appeal and set aside. It may be a condition was placed that I shall come later on immediately. This became the position to clarify that court twice that we have that court after considering Ashoka Marketing and the Jain case, they have considered opinion that there is no conflict with the Constitution bench judgment, and the tenants or person occupying a premises, a public premises, on the date of 16/7/1956 will not be affected by the rigors of Public Premises Act. Yeah, outside our. This is not both.
Sir, this
One thing, Milord, I must point out here.
This National Textile Corporation, that Constitution bench judgment.
Constitution, Ashoka Marketing.
No, in para 9 of this judgment.
Jain.
Huh?
Jain.
I have brought that judgment.
Jain.
Kaisar-i-Hind.
Kaisar-i-Hind.
Kaiser. Kaiser-i-Hind, 2002, volume 8, Supreme Court cases 182. আনতে দাও তাহলে 2002 ভলিউম 8 SCC একটা দিন আমরা অন্তে দিচ্ছি। আপনি একটা আমরা আমি একটা আনাচ্ছি, আমরা তোমারটা আনাও একটা 2002 লিখে দিচ্ছি। এখানেই আছে, ও এখানেই আছে। লিখে দিচ্ছি, লিখে না লিখটা এই যে আমি লিখে দিচ্ছি। This observation is incorrect. 182. এই নিন। Presided.
2002 ভলিউম 162
47.
ক্ষেত্রে
Yes, sir.
That here I must point out, as I'm instructed now, that this judgment, correctness of Professor's case, has been referred to a larger bench by another division bench. We haven't got the order of reference. I'm told that is without any reason. Just say we differ and refer to a larger bench. And larger bench has not yet considered this. So law as it stands now is a law of that Profil's case. Because, my lord, even if matter is referred to a larger bench by a coordinate differing bench, the coordinate differing bench cannot overrule. So, unless the larger bench overrules, that for the time being, High Court have to follow judgment of this. You point the
pregnancy হলে PP Act
necessarily, the Central Act will prevail. That's right. Repugnance will prevail. Could be. Or 254(1). Court may be in concurrent list, but state could report. But which is earlier. Earlier law, which is state law.
But I have the book.
It's okay, that in.
No, PP
There is still a premise system.
No. Public.
You get it?
And
It's a copy card.
my lord, I have a copy.
97 Act. You know, Lordship, can you first consider 1956 Act?
No,
That point of time,
PP Act was in
okay.
1971.
Yes, 1971.
71.
Take it. Yes, ma'am. Kindly see that. Sorry. You took a big deal. You took a big deal. One more look more kill. For look more kill. I think কত লক্ষ কোটি টাকা দিয়ে নিজেরাই জানেন।
সব থেকে বড় লোক স্যার আপনার টার্গেট।
হ্যাঁ, এবং বড় লোক ক্লায়েন্ট থেকে পিঠা আসে অনেক বড় বড় ব্যাপার ছোটখাটো আমার হাইকোর্টে ছোটখাটো
Authority fees act, all of that fees act.
সাড়ে তিনটে হয়ে গেছে দিনের দুটো দুটো কপি পেয়ে গেল না দরকার ভিডিও
See the presidential assembly is being to some 16 September. You see the constitution. Paragraph 4, 30. Page number 207. And 40. Very clear.
When the 19 Public Premises Act came into operation, then, my lord, we are governed by the West Bengal Premises Tenancy Act 1956. It came into operation 1958. And under that act, these premises owned by LIC was within the ambit of the act, not exempted. And it's the same as Bombay Act. It may section 1, subsection 3 of the Tenancy Act of 1956.
West Bengal Premises Tenancy Act 1956.
And the bullet sheet.
Premises Tenancy Act 1956.
The copy আছে
আচ্ছা
আচ্ছা Section 1, subsection 3, my lord. Only, my lord, the government owned by the government or local authority, that was exempted. Section 1, subsection 3. Explanation. Proviso. Dear sir. The second proviso to subsection 3. These extend to the whole of Calcutta and to all areas, etc. I took copy it. But we have got second copy. Can you see, my lord, proviso, second proviso. Provided further, Act shall not apply to any premises belonging to or taken on lease by government or any local authority or requisition by the government. Local authority shall include board called the Trustees for the Improvement of Calcutta, referred to in Improvement Act, as well as any body corporate or authority that may hereafter be constituted under any law for the time being in force for the improvement of any municipality, town or cantonment. Same thing was in Bombay, that was considered in that. So, Miller is one thing. Here, Miller kindly then see, Miller, in our case, please see, Miller, can you take us stay petition? নোট করেছিল পাশাপাশি দিল এই মেয়েটি বোধহয় গুলিয়েছে এসেছে না আমার নোটটা এখানে নোটটা কোথায় গেল মুশকিল কোথায় তুমি নিয়ে চলে গেলে বোধ আবার বোধ একটা পাতা নিয়ে চলে গেছিল যে revision petition. Sorry, my lord. I'm giving you this. My lord, kindly come to page stay petition, page 89. চলে গেল তুমি ভাই ভুলে নিয়ে গেছে দেখো তোমার কাছে বলো কারণ এটা মুশকিল হয় কোনো উপকার নেই হবে page 89 below. This is 13 June 1991. This is agreement between the LIC Exchange and LIC. Revision of rent. This refers to our discussion on 7 June and you later dated 10 June 1991 on the above subject. It has been decided as under. Rent of the premises will increase from rupees 400 per month, rupees 900 per month with effect 1691. মেমোর নিচে ওইখানেই নোট করছো দেখো তো এইটাই ঠিক আছে and the range of the MSL will come upward variation by 35% after 5 years with effect from 1696. The tenancy will continue to remain as a monthly tenancy. Similar regarding revision of rent, you agreed that every 5 years there will be an enhancement of 35 years. Now the ground for termination of tenancy and this application of Public Business Act is that LIC wanted rent revision of ₹10 per square feet after the agreement. May I finish this? After this agreement was acted upon. Please similar page 91. This agreement acted upon. This is the LIC's letter to us. And page 92, my lord, is typewritten copy. We find from our record that existing rent of 900 per year per year tenancy stand revised with effect from 1696. Present rent is 1215. That is 35% escalation over the previous rent. You may kindly note the rent will be further revised by 35% with effect from 1st of June 2001 for a period of 5 years. And Millard, we paid the rent. No dispute regarding a revised rate of rent. Please, Millard, come to the copies are not put. Page 95. We are writing to them after 5 years, second revision. In absence, your monthly rent bill for the month of July 2016 for say TC number, etc., etc. Please find account P check number drawn on this bank dated 4th July 2016 for rupees 4,038 only. 4,038 only being the rent for the month of July 2016 per set. Further increase of two revisions of 35% each. So 1,215 rent became Millard, after the first division, 1st June 2000, it became 2019 one. Please come to Millard, page 94. Page 94. This is a receipt challan from them 6th of January 2015, deposit of rent, etc. So, Millard, rent is 2,991 before the 2016 amendment. So, Millard, there is no failure on the part of the tenant to pay rent as per the revision agreement. And we continue to send rent at the rate of 4,000 per month to LIC. Now, Millard, kindly come to notice to quit. On what ground where tenancy is being terminated? Page 115. Notice to quit of the same volume, Millard. Also find the same volume. 115. Page 115. This is the lawyer's letter on behalf of LIC to Dalhousie. On the instruction of the client, I write to you as follows. That my client is the owner of the premises, there is no dispute, Queen's Mansion, etc. Situated at Russell Street, etc. That you are occupying as recorded tenant in respect of premises being numbering given, area of 1200 square feet at 13F Russell Street, Queen's Mansion, which is more fully described in schedule at a monthly rent of 12,115. This is incorrect. Date of letter is 13/1/2003. By that time, the rate has been revised more than that. Anyway. And payable according to calendar month. That the revision of rent of the said number is given TC number falls due on 1st of May 2001. That's correct. But despite repeated letter written by my client to you for a most reasonable revision of rent and execution of the lease deed yielded no result. Why? That offered for reasonable upward revision of rent made by my client in view of the most rate of rent being paid by you for the commercial premises, that is that too in area of Park Street, etc. Revision of rent not as per the revision agreement. That is the first demand made by them. And similar to what they're asking for. Because I did not accept their offer for reasonable upward revision of rent, that is already covered by the agreement. So, what is the fault I have committed? I have been therefore instructed the client to call up a quid vacate on the expiry of 2003. That was the ground. Now, in 2005, my lord, that notice under section 4. Now, this, there has been no breach of tenancy agreement on our part, and our no reluctance on our part to pay rent as per revision agreement. Then I am a genuine bona fide tenant. Even if, my lord, even if the Tenant Public Premises Act applies to me, I'm taking alternative case which is argued. Even if the alternative argument, even if Public Premises Act applies to me, although I'm occupying before the commencement of the act, even then, is it reasonable or fair on the part of a government landlord on Article 12 authority to take recourse to Public Premises Act and evict me on the ground that LIC want to go back on the revision agreement and want a rate of rent which unilaterally enhanced by them. That will be made clear, not the amount what they're asking for, that will be made more clear later on. Now, please come to notice under section 304. Lordship has seen the Public Premises Act. May I, before that, place section 4 and then show you, my lord, the notice. Issue of notice against order of eviction. Section 4. If the estate officer has information that any person is an unauthorized occupation of any public premises and that he should be evicted, the estate officer shall issue in the manner hereinafter provided a notice in writing written 7 working days from the date of receipt of the information regarding the unauthorized occupation, calling upon him calling upon the person concerned to show cause why an order of eviction should not be made. The show cause notice has to be issued under law. And 1A, they have not issued 1A. If the establishment knows or has reason to believe that in person is an unauthorized occupation of public premises, then without prejudice to the provision 1, he shall forthwith note. But in this case, notice was issued under subsection 1, not 1A. They were delayed. Then 2, subsection 2 is important. The notice shall specify the grounds on which the order of eviction is proposed to be made and require all persons concerned, say all persons in the occupation, so called if any. Grounds have to be mentioned. Now there is a statutory format of the notice. Form number 8, prescribed under the rules. My lord, in that book has got public rules also, my lord. No?
Yes.
Yes, my lord.
Form number?
You did not kindly come to rule 3. A notice or under the act, a notice or order under the act shall be in one of the appropriate forms appended to these rules. Now, my lord, please come to the rule, the format of section 4 notice. Form A, which may be without page 33. If I look at the same book, no, we are not looking at the same book. Form A. Thus, you can form of notice under subsection 1 and clause B2 of the X section. This is important. Well, not kindly see the what is requirement. Whereas I, the undersigned, am of opinion. Kindly mark this. Am of opinion. On the grounds specified below, that you are in unauthorized occupation of the public premises, mention schedule, that you should evict it from the said premises. Then grounds are set out and show time limit is show cause notice, etc., etc. And in person, and in the, now therefore, in premise person section 1, section 4, call upon you to show cause, etc. Now, I'm going to now come to the notice below and see whether this is as per the law. Page 378, that will be volume 3. No? My lord, kindly. Kindly come to page 380, that is type copy, perhaps more easy on the eye. Page 380 typed copy, my lord. No, sorry, I made a mistake. That was I'm sorry. For May, at 378, there is no type copy of this. That is another note. For May, can you see the notice under subsection 1, B2 of subsection 2, not subsection 2, subsection 1, 4, subsection 1. Whereas I, the undersigned, am of the opinion on the ground specified below that you are an unauthorized occupant, public premises mentioned scheduled below, you should be evicted from the premises. You, opposite party, was tenant in respect of suit premises, fully described in the schedule below at a monthly rent of 1215. That is wrong, incorrect statement. On the basis of last revision of rent in 1996, I'll show that incorrectness to your lordship. You, the opposite party, have failed. What I failed? Failed and avoided to enhance the rent with effect from 1/6/2001 at the rate of ₹10 per square feet. Whether on the revised rent, it should be 35% increase. And the revised then it come to about 2,000 and odd, which I show Lordship we deposited the amount, their documents to show that. 10,000, 10 rupees per square feet, in spite of several requests made by the applicant is a LIC. We have also not executed fresh lease agreement after expiry of earlier lease. There is no earlier lease at all. The monthly tenancy, the letter itself says. Lordship revision letter, they say you are to a monthly tenant. The second demand I am not supposed to have complied with. You, the opposite party, have proceeded with the repair jobs without the knowledge and consent of applicant. Repair jobs do not require landlord's consent under no law, and Miller causing damage to the building which is hated. But that is a new ground. This is not the ground for termination of tenancy, that you are damaging the building by repair. This is new ground. Then Miller occupy, etc. Now Miller having this in mind, so opinions formed on this basis. Lordship find us Act Section 4. The estate officers has to form an opinion. Just because the tenancy has been terminated by a notice on 106 or the Rent Act notice, whatever it may be, he is not to start Premises Act, not to apply the Premises Act. He has to form his own opinion. Lordship has seen Section 4 do not contain any guidelines. When the estate officer can do so, and when the tenancy can be terminated. No guidelines given. So, my lord, that was a lacuna, and Ashoka Marketing itself has said that this is a very draconian law. It should not be used at rampant. It is used for some specified purpose, namely for ousting generally unauthorized occupant who was occupying the public premises without an authority, and to evict the employees whose tenure has expired, but still they have not vacated. Apropos this, not kindly see to prevent this arbitrary use of the power or discretion to apply PP Act. The guidelines were given by the office order of the ministry. What are the guidelines given? Please will not come to page 121, the volume 1. Volume 1, page 120, Office Memorandum, dated February 19, 1992, soon after Ashoka Marketing judgment. Public premises, etc. Its subject, Public Premises Eviction Occupants Act, parameters to be followed by PSE, Public Sector Enterprises. The Public Premises Eviction Act, known as PP Act, provides for eviction of unauthorized occupants from public premises by a state officer appointed by government of the public authority, and provides for a summary procedure for eviction within 15 days of passing of eviction order. The scope of this act was expanded through an amendment in 1980 in order to bring within the purview the properties of companies defined under Section 3 of Companies Act, in which 51% share has held. That is not relevant here. The cardinal principle of this amendment was removing the difficulties faced by these bodies in evicting unauthorized occupants, including their employees, no longer in service, from the premises owned in their institutions. Then 2, this guideline. Although the provisions of PP of Public Act, of Eviction Act, has been upheld by the Honorable Supreme Court in the case of Ashoka Marketing Limited and various other civil petitions. Supreme Court has also observed that every activity of the public authority should be guided by public interest, and they should deal with their tenants distinctly from private landlords. The matter has therefore been further examined in the government having regard to all the relevant factors. It has been decided that PSE should not use the PP Act to evict, my lord, evict genuine tenants, which undoubtedly my client has been, but use the Act primarily, the illegible something. What have you got a copy? Better copy. I'm sorry, but this illegible is primarily, I'll get it from the other. This blank will fill up from other circular also. Primarily, my lord, at the same time, it has been decided to prescribe for the benefit of all these organizations a set of guidelines in order to prevent, this is not quality, prevent arbitrary use of the provisions of PP Act to a lot of printing mistake, to evict genuine tenants, arbitrary use of the Act to evict genuine tenants, and to limit the use of the summary power primarily to avoid unauthorized occupants and retired employees of the enterprise. This will ensure companies with the spirit underlying the protection extended by the Parliament to these premises and the observation of the Supreme Court while upholding validity of the amended Act. The guidelines given below set limits for resort to PP Act by PSCs and are to ensure that interests of the genuine tenants are not jeopardized. The following are the guidelines. Provisions of PP Act should be used primarily to evict totally illegal occupants of the premises of public authorities or unauthorized sublets or employees who have ceased to be in their service and thus ineligible for occupation of the premises. The proceedings should be initiated in accordance with the provisions of the Act, only cases where the occupation becomes unauthorized on genuine grounds of law. B2. This provision of the Act should not be resorted to either with a commercial motive, as they're doing, increase the rent to 10 rupees, then it's all right. Then I am not an unauthorized occupant. Commercial motive, or to secure vacant possession of premises in order to accommodate their own employees, that is not applicable. Then 3, a person in occupation of any premises should not be treated or declared to be an unauthorized occupant, should not be declared an unauthorized occupant, merely on service of notice of termination of tenancy. Nor should any contractual agreement be wound up by taking advantage of the provision of the Act, as the 3 million. The agreement or revision is being sought to be wound up by them. Sought to be wound up by them.
Yes.
But they under threat of Eviction of Tenancy Act. At the same time, it will be open to the public authority to secure periodic revision, secure periodic revision of rent in terms of provision of Rent Control Act. At 1995, the revision agreement was entered into following these guidelines. In terms of the provision of Rent Control Act, and each state ought to move under genuine grounds under the Rent Control Act for resuming possession. In other words, public authorities would have right to similar private landlords under the Rent Control Act in dealing with genuine legal dealing. Which means this was followed. In terms of Rent Control Act, in 1995 is what? Revision of rent agreement was intended to, and it is so. It is necessary to give no room for allegation that eviction was selectively resorted to for the purpose of securing an unwarranted increase in rent. Similar, unwanted increase in, exactly that's what they've done here. Or that a change in tenancy was permitted in order to benefit particular individuals or institutions. In order to avoid such imputation, abuse of discretionary power, the release of premises or change of tenancy should be decided at the level of Board of Directors of public sector undertaking. All the public undertakings should immediately review all pending cases before the estate officers or courts with reference to these guidelines and withdraw eviction proceedings against genuine tenants. Last paragraph, similar, I'm very important. All the administrative ministries, Department of Government of India are requested to bring, again eligible, to the notice of the PSCs under the administrative control for strict enforcement. These guidelines may also be given wide publicity and copies given to all Ministry of Development, etc. And Milord, this is issued by Department of Public Enterprise, Ministry of Government India, Ministry of Industries, the Department of Public Enterprise. Now, the second argument which was made in this case, that the power or the recourse to PP Act in this case was arbitrary, unreasonable. To that, Milord, normal answer was that these are guidelines. These are no legal force. Then the next question is this: if there's no guidelines and no legal force, are they waste papers? Or it has to be borne in mind before taking a decision. Because there in the Act, there is no guidelines. Under the Act, a tenant with a genuine tenant, Tenancy Act applies, or Transfer Property Act applies, he is there in a property. Then that property, let us say, is purchased by LIC or some other government companies, full of tenant. Then can the government company, after purchasing, evict all the tenants by taking recourse to PP Act? Will that be fair? Will that serve the purpose of the Act? I'm not saying there's a different thing by having a legal force. Legal force, had it the legal force, I would have said your action is illegal. I should have, your action is illegal. I'm not saying so. I'm saying your action is arbitrary, unreasonable, not befitting an authority under Article 12 of the Constitution. This is the second point with urged. For the deliberation, several judgments were cited. It is noted in the judgment, my lord. My lord has very carefully gone through, and he has followed the judgment regarding the guidelines. His lordship said these are guidelines not having legal force, does not give the tenant a legal right. Yes. I have perhaps no quarrel with that thing, but my assessment or my humble submission is very well, it may not have a legal force. I'm not saying it's illegal, but now consider it from the point of view Article 14, whether this LIC, public authority, who is obliged to act fairly and reasonably, has done so. And whether this case was fit case. Lord, see, the ground was, only ground, really ground is that I shall have not agreed to enhance rent in violation of the revision agreement already entered into. That is completely against the guidelines.
Yes, not.
That is the only ground. Second ground, I am repairing my premises. Repairing is not at all any objection. And that was not the ground in the tenant termination notice, that etc. And you are not inclined to repair. I said that now to show the encouragement, I've shown your lordship that agreement was acted upon. And 92, page 92, we deposit the rent. And Milord, at page 95, I've shown your lordship, we sent the rent at the rate of rupees 4,000. Because that was the revised rent. If they ask for revised rent, I have no objection. But now, Milord, if they want that increase the rent, that matter of mutual discussion and settlement. We are not averse to that. But we are only objecting to this. You, however powerful you may be, you cannot unilaterally decide to wind up an agreement.
Yes.
You can unilaterally cannot do so. But unless 2011, 13, but unless these guidelines, these are guidelines to avoid arbitrary, is explicit to avoid arbitrary use of this power or discretion. Let may I say it, one judgment of Supreme Court, 2011, volume 13, Supreme Court cases, 446. I read only one paragraph, 92, long judgment, 92. This is under that. Please, Milord, come to paragraph 92 at page 488. Heading, expectations from public bodies. Although, paragraph 92, although the question of maintainability of the standard rent applications concerning the public premises is only coming up now before this court, we have referred to the views of the courts when different facets of this issue came up for consideration from time to time. Exemption from Bombay Rent Act to the government premises was upheld by such judgment on the basis of the presumption in favor of the constitutionality of the enactment, which is also on the footing that the legislature correctly appreciates the needs of its own people. Chief Justice Chagla has clearly observed the matter that the legislature was not in any sense exempting the government from operation of the act in order to permit the government to do the very thing which the legislature was prohibiting the landlords from doing. Not to increase rents, not to eject tenants unless it was absolutely necessary in the public interest. Justice S.R. Das, as his lordship then was, has also observed similarly in Baburao Santanam More that it was not expected that the government or a local authority would be actuated by any profit-making motive, as examined in this case, so as to unduly enhance the rents or eject the tenants from their respective properties as private landlords are or likely to be. Justice Shobhushaji Mukherjee, as he then has gone further in Dwarkadas Matfatia and observed that when public authorities enjoy this benefit without being hidebound by the requirements of Rent Act, they must act for the public benefit. And to that extent, the issue is liable to be gone into and can be just subject matter of adjudication. He has stated in no uncertain terms that the legislative expectations, as observed by Chief Justice Chagla in Rampratap cases, cannot make such conduct a matter of contract pure and simple. He has further observed that the exercise of discretion of public authorities must be tested on the assumption that they would not act as private landlords and they must be judged by that standard. We may, however, add that these principles will have no relevance while considering a dispute between a statutory body as landlord and the affluent tenant in regard to a commercial or non-residential purpose. This is not good said. But this 1200 square feet shop holder, sorry, we'll have to, shall we stop because of this? Maybe reasonable or unreasonable request. When Lordship will be taking up this matter, Miller, tomorrow, that may I ask for keeping tomorrow only, Miller. Day after tomorrow, kindly. Lordship make it. Not possible. Then Miller, my junior will do it.
Tomorrow will, how much time you would require? You have concluded or?
Tomorrow.
No, how much more time you would require?
Also like that, one. Maximum honor, not within. I have to place the judgment of the learned judge below. The judgment have to place.
So would it be within by tomorrow or within this week?
Yeah. No, I'm just saying day after tomorrow. If that is convenient for Lordship, otherwise, Miller, I shall make arrangements. I am already on my legs somewhere else. Judgment can be placed by if any.
How much time you would require?
Well, with the deepest of respect, my time depends how much he's.
The thing is, you please have a realistic approach.
My name.
We can't be going on. Our regular board is stuck.
Of course, Lord. Well, that is why you indicate.
See, already facts have been placed.
My Lord, I will not take to the facts. I will only, my Lord, confine.
You answer the legal issue.
Only.
And the factual issue, they say there is no.
Lordship, I will not travel to Lordship. But why did I say that my time? Because I could only answer only to the extent that he has argued. Because I do not need to answer any other questions.
Sir,
so
essentially, there are only 3 points.
My Lord.
You please frame your.
I have already framed, but subject to corrections, I will try to answer. These are only 3 points. Subject to correction, but may I just also, your Lordship may indicate the 3 points that your Lordship is.
No, you tell what are your 3 points.
No.
First is jurisdiction they have raised.
My Lord.
First issue is that. Second is he is not a defaulter.
Not a defaulter, bona fide tenant.
Bona fide tenant. So the provisions of the act will not.
My Lord.
Thirdly, your action is arbitrary, irrational, and violative of Article 14.
Contrary to the guidelines. My Lord.
You are a statutory person,
My Lord.
public sector, you have to be benevolent and fair and reasonable.
But even if there are no guidelines, we are bound to act reasonably under being Article 12.
But I would show that is a test of reasonableness that we would pass through.
But they can't raise this argument if they were a private person. Because the LIC would.
কালকে অরবিন্দই করে দিক আমি কাছে বলেছি
$12 tomorrow. 12 noon.
Tomorrow. Then Lordship may have to excuse me. Let my junior will place the fact. Then I was requesting, but day after that, if that is inconvenient.
Day after there is some inconvenience for continuation of argument. Tomorrow.
Tomorrow at the second half or first half? Can it be in the first half, my lord?
First half.
First half. Then it's
12 noon.
12 noon. 12 noon. Oh, then all right. Oh, best. 12 noon all right. And the second half I have it.
No.
Commitment.
And we will please both of you endeavor to finish it by 1:15.
Please. 12.
Because beyond that, it's very difficult to manage the boards.
That's when I always, I myself
And
like
if at
continuity.
all council wants
12
to,
noon is all right.
wants to
I
put
like
something in
continuity.
writing, he can always put it in writing.
I really,
Subject to corrections, at least so far as my turn would come after my adversary would finish. At least give me some, I can understand my lordship so much predicaments, my lord. and other matters, but at
Today
least,
is
my lord, do not,
3:30.
my lord,
Today is
at least do
3:30.
not put me with, my lord, such a clock that, my lord, after at least let them finish.
All right.
After my, my lord, may I take my book, my lord, that grateful, lord, deeply obliged. Deeply obliged.